We have received the.
You have received a report.
Some difficulty, Lordship. Let it be on Monday, Lordship.
No. On 19th.
19th is? 19th. Huh?
19th June.
19th. June.
Your name?
My name is D. Dekar, Lordship.
Learned Counsel Ms. D. Dekar has prayed for adjournment. List the matter on 19th June.
May Your Lordship, I beg to mention item number 36, Lordship. We have filed Wakalat number today for the informant, Lordship. That may be called for, Lordship.
Okay.
36.
All right.
May it please your Lordship. My Lord, I beg to mention for listing of a bail application, Lordship. For bail hearing, it was last listed on 5/6/2025, Lordship.
You'll have to mention before court number 11, Nikki.
11, Lordship, less than 7 years, Lordship.
Then you'll have to mention before Justice Mary Colta.
Obliged.
May it please your Lordship. I beg to mention item number 9, your Lordship. In this matter, Senior Counsel Mr. B. Datta has some personal difficulty today.
Learned Counsel Mr.
B. Datta.
B. Datta on behalf of Learned Counsel Mr.
J. Das.
J. Das has prayed for adjournment. List the matter when you want.
8/6, your Lord. 18/6, your Lordship.
Not on 18.
19/6.
On 19/6.
Deeply obliged, your Lord.
Okay.
Please, Your Lordship. Lordship, I beg to mention item number 40. Lordship, the conducting legal aid counsel is on leave. Therefore, the matter may kindly be taken up next week, Lordship.
Who is the conducting legal aid counsel?
Dr. P. Agarwal, Lordship.
Okay, yes.
Item number?
40.
The conducting 14, no? 14.
40, Lordship.
The conducting legal aid counsel, Dr. P. Agarwal, is on leave. List the matter on when you want. After 1 day.
25th, Lordship. 25th may be allowed.
Okay. 25th, fine. On 25th.
I'm humbly obliged, my Lord.
May I please, Your Lordship, a listing of IA criminal, Your Lordship, right, for suspension of sentence, Your Lordship. On 19 similar matter.
Court number 3. Court number 3. Court number.
Obliged.
May I please your Lordship? Lordship, I am appearing from on behalf of Anna Ahmed, Lordship, for the criminal petition, Lordship.
Learned Counsel Mr.
I Islam, Lordship.
I Islam. Vice Learned Counsel Mr. N. Ahmed is present and has submitted for and has prayed for withdrawal of a petition under section 528 of the BNSS 2023 read with section 482 of the BNSS. First, Mr. B. Sharma, learned additional PP.
Lordship, with liberty, Lordship.
Oh yes, petition is dismissed on withdrawal with a liberty to file a fresh petition.
Obliged, Lordship.
Item 1. Item 1.
May I please, Your Lordship? The conducting counsel for this
Okay, okay,
is
tell
on
me.
leave, so I request for the passover for the time.
Passover for a day. Learned Counsel Miss. Your name?
My name P. Burman.
P. Borman, Vice Learned Counsel Mr.
S. Hussain.
S.
Mr. S. Hussain.
S. Hussain
Yeah.
has prayed for adjournment. List the matter after
No, Your Lordship, for passover for the time being.
time being. Oh,
My lord, here 22C, my lord.
Ah.
Here they have also passed come from 50 notice under section.
we'll call for the scan
Yes, yes,
copies of
scan
the
copy,
trial
my
court
lord.
record.
Lordship.
Call for the scan copies of the Buckingham Criteria. Call for the scan copies of the trial court record along with the scan copies of the CD. List the matter on when do you want? After vacation.
Short date, Lordship, before vacation, short date, maybe.
Before vacation.
124, Lordship.
26 June.
Obliged.
May I please your Lordship?
Yes, yes.
So second bail application, Lordship, the last bail application that was rejected on 24/7/2023. Lordship, the person, the petitioner is a cardiac patient, and I've annexed the document also, Lordship, it's a page number 32 annexure 5, Lordship. And the thing is that, Lordship, the FIR, if your Lordship kindly see the FIR, it is at page number 22. I'm just, before that, Lordship, I'm just reading the page number 20, the initiation of the allegation, Lordship. Now petitioner is the executive engineer, Lordship, and they were, along with the district development commissioner, a committee was formed, and the district development commissioner is the head of the authority. And along with the district development commissioner, the petitioner was entrusted with the.
All right, your bail petition was rejected earlier.
Exactly,
Lord.
Lordship.
So let us see your.
Lordship, this, why I'm submitting
No,
this
no.
one, Lordship, yes,
Let us see your ailment. What is
Lordship,
it? What? is
exactly,
the-
Lordship, it is at
New government.
Lordship, annexure 5, page number 32, Lordship. He is severely suffering from cardiac problem, Lordship. Page number 32, annexure 5, Lordship. After careful examination of the patient, scrutinizing previous prescriptions and preliminary investigation, I found him that he is complaining of some complaints with an increase in length. He is also suffering from uncontrasted hypertension in his lung. Considering above, I advise him to consult an expert cardiology in a reputed cardiac center on outside immediately, as he may require surgical intervention.
My lord, here, Lordship, earlier it was rejected after going to the case diary, my lord. Here, in the earlier occasion also, they have submitted some medical documents, my lord. It is reflected in page 34, my lord. Medical documents reflect advice to the petitioner for ECG and cardiograph, my lord. Here, that medical report is there, my lord, but
This
it
is
was
not a new ground, no?
Lordship,
Earlier you have.
this is a
given
new
us-
certificate, Lordship. That was the different medical certificate, Lordship. This is of 2025, Lordship.
And
And why I'm referring to this particular page of the FIR, Lordship, because the concerned person who is the head of the authority, he has made certain allegation against the petitioner. But where from he has come to that conclusion, that some financial irregularities have
So
been
we are
made.
going into all the nitty-gritties. What is the ailment that?
My
Lordship, the cardiac, the page number
Any
2.
any new ground that
Fine.
is.
Exactly, Lordship. This is the new ground, Lordship. I have been advised to go to Calcutta or outside state of Assam for the surgery, Lordship. Lordship, kindly see annexure 5, page number 32, Lordship. I will cooperate in all possible forms, Lordship, but considering the health condition, I will.
Okay then,
my lord.
interim bail,
But offenses are of very serious in nature, my lord.
more than half, 53 lakhs he has.
My lord, my lord.
I have no role, Lordship. That is the reason why I'm submitting repeatedly,
No,
Lordship,
no,
with regard to
it is-
this page number 20. Not a single whisper against me. What wrong I have committed? And
But-
I was the subordinate authority, Lordship. I
See,
had
I have rejected.
Case diary,
to
after
the
position of the case diary, it was rejected, my lord.
Our learned counsel, Mr.
SP Chaudhary, Lordship.
S.B. Chaudhary, for the petitioner. Sudip Soka, who has filed this application under section 482 of the BNWS 2023 with prayer for pre-arrest bail, as he is apprehending arrest in connection with Sashi has been submitted.
Charge sheet has been submitted.
Shashi
No, sorry, Lordship. Charge sheet has not been submitted.
Investigation is going.
Yes.
So and so PS case under so and so sections. His earlier prayer for bail was rejected by the order dated 15/2/2023 in connection with AB 3838/2022 and AB 2102/2023. The petitioner has submitted the petitioner has prayed for interim bail on change of circumstances, as he is seriously ailing and he is a heart patient, and advise surgery outside the state of Assam. Seen the
Annexure 5, page 32, Lordship.
medical certificate marked as annexure 5. Heard Mr. B. Sharma, learned additional PP Assam, who has raised serious objection, stating that earlier the petitioner has come with the petitioner was before this court with the same ground. Per contra, the learned counsel for the petitioner has submitted that the petitioner has submitted a new certificate dated 21/4/2025, and the petitioner's condition is serious. Full stop. Moreover, the petitioner has been falsely implicated in this case. I have considered the medical certificate submitted and marked as annexure 5. It appears that interim bail may be granted to the petitioner till the next date of listing. Call for the CD, list the matter on. On 17 July.
70.
Aru eta likhi diasun, line to additional PP. It is submitted that the allegation against the petitioner is that he has misappropriated public money worth rupees more than 50 lakhs.
My lord.
Obliged, Lordship.
All for the CD, already 50,000, which is in the interim, the petitioner shall be enlarged on bail of rupees 50,000, which is the total surety of like amount to the satisfaction of the arresting authority under the condition that the petitioner shall refrain from such activities with which is arrest, with which is alleged. Number two, the petitioner shall not leave the jurisdiction of the court without, you'll take permission, huh?
Yes, Lordship.
Every time you leave the court, shall not leave the jurisdiction of the court without prior permission. The petitioner shall not tamper with the evidence. On breach of any of the bail conditions, the bail order shall automatically stand cancelled.
Lordship, for medical reason, Lordship, I will take due
Take
consent from the,
permission from the.
due consent from the consent, the authority, Lordship.
The court will
Mm,
take
yes.
court, it's mentioned as court.
Yes, Lordship. Obliged, Lordship.
May I please, Lordship? Lordship is POCSO matter, the CD as well as a notice may be issued. And a refu,
Petitioner to take steps to issue notice to the respondent number respondent number two,
Lordship.
returnable on, you want a date
Yes, Lordship.
Before
CD
vacation?
CD also maybe.
before vacation,
No, my lord,
No.
after vaccine.
after vacation.
After vaccine.
After vacation date, that is. Meanwhile, call for the CD.
Lordship, one more report may kindly be called for. Actually. As per the birth certificate, the age of the victim is 13 years old. And as per the school certificate, the victim's age is 18 years plus. So I have say annexed both the certificates. May kindly be called for the report from the concerned authority like the DO Lahori.
No, this is the not the.
Okay.
May I please, your lordship?
Hmm.
This is a transfer petition, lordship. The petitioner wife filed an application for a recovery of her Sridhan, lordship. But lordship, the case is at evidence stage. But on last occasion when she went to Morigaon, lordship, now she's living in Guwahati. Went to Morigaon, her husband threatened her and her children such a way she lodged an FIR. Lordship, may kindly see page number 52, lordship.
Transfer petition will issue notice. Will issue
And in the
notice.
meantime, lordship, otherwise, lordship petitioner will be suffered by because she is living in Guwahati, lordship. And due to this, she filed this application, lordship. And in DV Act also, this honorable court state the proceeding, lordship. Though both the matters may come together, lordship.
Her husband resides at,
So, lordship,
where does her husband reside?
Morigaon, lordship. I am out of fear, lordship, living in Rihabari, Guwahati, lordship, along with my children. He is threatening me such a way. I am praying for transfer to Guwahati and I am filed 125 at Guwahati, lordship. It will be easier for
And this
me.
appeal is relating to which case?
This is regarding DV Act, lordship, we have submitted. This honorable court state the proceeding. I am praying that both the matters may come together.
And this is relating.
This is regarding recovery of Sridhan, lordship.
Okay. Her learner counsel Miss
As Kanungo.
S. Karan Go for the petitioner, Napoli Himanalage, who has filed this application under section 447 of the BNSS 2023 with prayer for transfer of the CR case number 40/2020. This case is for under
Recovery of
section,
Sridhan.
under section 406.
406.
Under section 406 of the RPC, pending in the court of the
CJM Morigaon.
CJM Morigaon. It is further submitted that the petitioner was threatened by her husband and the petitioner had to lodge an FIR. And the petitioner is under threat if she under threat and she is hesitant to appear in the before the court of the learned CJM Morigaon. It is further submitted that in connection with transfer P within bracket criminal 8 of 2025, the petitioner's matter for my proceeding registered as Miss Appeal number 16/2023 has been stayed. Full stop. The petitioner has prayed to tag both the matters together. I have considered the submissions at the bar Now, I have considered the submission on behalf of the petitioner. It appears that further proceeding of CR case number 40 of 2022 may be stayed in the next date of listing. Meanwhile, issue notice to the respondent returnable within 4 weeks.
Lordship, both the
List
matters may come together.
returnable within till next date of listing legal and not stayed. List this matter along with list this matter after 4 weeks along with TRP criminal 8 of 2025.
Deeply obliged.
Item 5.
That is your lordship. Well, this is an application for transferring the FC criminal case, which is filed under section 144 of BNSS from FC Family Court at Guwahati.
Or
to
44 of BNSS.
That is a maintenance case. From Guwahati Family Court, Guwahati to Sribhumi and JMFC Sribhumi district.
You are doctor, you are the husband.
I'm the husband.
You'll issue notice.
Well, only thing is that on last two occasions, the husband could not, he is a doctor and a senior medical and health officer of Civil Hospital, Karimganj. And he is not in a position to appear before this family court, where under section 13, he has to personally appear. And the next date is on 26th of July. Well, till then, this proceeding may be stayed. This absolutely.
No.
Well, earlier, the respondent also filed a transfer petition that has been dismissed by this honorable court. My lord, will kindly see page 36. Now, on the pretext that she is pursuing PhD degree in Guwahati, she filed in an application in Guwahati. She hails from Silchar. Page 36, and operative part is page 38, paragraph 9. She is contesting the divorce case filed by the petitioner hearing in Sribhumi through her counsel. And now just to harass the petitioner hearing, she filed a maintenance case here in Family Court, Guwahati. As your lordship, on page 38, paragraph 9.
She is pursuing what?
PhD.
PhD.
For PhD, she is not required to present here in Guwahati for long.
This case is pending in the family court, Guwahati.
Family court at Guwahati. And the divorce proceeding is pending before the district judge, Karimganj, now Sribhumi district. There she is appearing, and just to, as a counterblast for dismissal of her transfer petition, she filed a maintenance case here in Guwahati, saying that she is pursuing PhD degree in physiotherapy. That too. That too in physiotherapy. For this course,
She's a doctor.
No, she is a physiotherapist. And the husband, the petitioner, is a doctor and senior medical health officer. And she has also got her clinic at Silchar, physiotherapy clinic.
Which is the case which is pending here? Other case? You have stated that pending in Silchar, the other case?
No, not in Silchar, not
Sribhumi.
in Sribhumi.
Which is the other case?
The divorce proceeding, madam. Divorce
Which was
proceeding.
rejected to be transferred. Yes. This case.
She prayed for transfer of divorce proceeding to Silchar. That was rejected.
This case is pending at which stage? This maintenance case?
This maintenance case is pending before the family court number 2.
Which stage?
We have filed the affidavit and the counseling, now counseling.
Oh, counseling.
Counseling.
All right. Counseling? Stay of counseling? It'll take 3 months only.
My lord, the only problem is that on last two occasions we have annexed the documents. He is the only senior medical and health officer of the criminal civil hospital, which is the only government hospital in the Srivimi town area. He is catering 1,50,000 patients there, and it disrupts his service, healthcare services.
Good. Third learned counsel, Mr.
Eighth.
Adhor,
Yes.
for the petitioner नाम लिखिएगा हाँ. State till the next date of listing. First filed an application under section 447 of the BNWS 2023 with prayer for transfer of FC criminal case number 543 of 2024 pending in the court of the learned principal judge family court number 2 Kamrup M at Guwahati to the court of the judicial magistrate first class at Sri Bhumi. It is submitted on behalf of the petitioner that earlier the petitioner had prayed for transfer of
Respondent is paid.
Huh?
Earlier respondent paid.
earlier the respondent, not petitioner, earlier the respondent had prayed for transfer of a divorce proceeding.
Title suit divorce 15 of 2020.
Registered as title suit TS divorce, case number 153 of 2022, from the court of the district judge Sri Bhumi to the court of the district judge Silchar, Assam. It is further submitted that in the pretext of pursuing PhD as a physiotherapist, the petitioner has filed a petition for maintenance in Guwahati, whereas on the other hand, the petitioner is contesting a divorce proceeding at Sri Bhumi.
Yes.
It is further submitted that petitioner or respondent in the
Respondent.
respondent has on the petitioner is a busy medical practitioner and he has to attend to at least 1 lakh
1.5 lakh.
1.5 lakh patients as in the civil hospital at Sri Bhumi, as the civil hospital is manned by only a few doctors, medical practitioners, not like doctors, few doctors. It appears that further proceeding of the respondent's prayer for transfer to TRPC 114 of 2023 was rejected by a coordinate bench of this court by order dated 29/4/2024. I have considered the submissions on behalf of the petitioner. It appears that further proceedings of FC criminal case number 543 of 2024 may be stayed till next date of listing. Issue notice to the respondent, returnable within 4 weeks. Meanwhile, further proceedings of FC criminal case number 543 of 2024 is stayed till the next date of listing. List accordingly.
Obliged, ma'am.
My lord, may I do this? My lord, there is a revision petition filed by one of the accused. My lord, we'll see the order at page number 75. It is starting. My lord, before I begin, my lord. So in this case, my lord, the co-accused have already been granted the
Bail.
privilege of bail, my lord, and the proceeding has been stayed. My lord, that order is there. So
You have annexed the order?
no, my lord, because it was. Pardon.
Actually, you should annex the order. If you're relying on this order, then you should. annex
My lord, I'm extremely sorry, my lord. I'm extremely sorry about this, my lord. My lord, may I peruse it? For a moment, my lord, his entire relation to this case is this man, lord. My lord, his brother, who was one of the co-accused, had signed a check Now, in this case, my lord, the presumption which the learned trial magistrate is taken, it is a company.
This is NI case.
Yes, my lord. It's an NI.
Finally decided,
Yes, my lord, it's finally been decided.
finally decided. This
My
is
lord.
revision petition.
Yes, my lord, it's a revision petition.
Earlier, you have preferred an appeal against
Yes, my
the
lord, I'll let
lower
my,
court's order.
yes, my lord.
We can stay, you'll have to deposit 20% of their.
My lord, it is, my lord, in this case, I'll submit, my lord, it may not be required because the cognizance itself has been taken under wrong provisions of law.
Aren't you?
My lord,
You're the accused.
I am the accused.
No, no,
but
I'll not go into the details. If
my
you
lord,
want
but
to
if the
stay, then you
cognizance
have to
itself is
deposit.
taken under wrong provisions of law, my lord, that the order itself cannot sustain, my lord. My lord will, for a moment, my lord, let
So
me
if for waiver of this 20 for waiver to deposit 20% amount, you'll have to file an application. Have you filed an application?
my lord, it is, my lord, at the lower stage, what had happened, my lord, his appeal could not be taken. His appeal was decided ex parte, my lord. That is what has happened. He, the counsel who was there had not been present on few days, and that is the way the appeal was dismissed.
No,
and
see, if you want a stay, I'll definitely grant a stay. What is the total amount?
my lord, it is twice the value of the check has been given, my lord. That is, I think, 1 lakh.
So that 20% of that will be how much?
My lord, it is 1,38,060,
So
my
how
lord.
much is 20% of 1,08,000?
Lord, can be that, my lord, that to be
1 lakh will be 20,000
my lord.
or 2,000, and then 8,000 will be
1
maybe
lakh will
around
be 20,000, my lord.
1 lakh will be
20,000 and
20%.
38,000 will be probably
20,000, yes. 1 lakh will be 20,000 and 8,000 will be something like that.
around 7,000 more for 38.
27,000 maybe.
But my lord, I'll address this point, my lord. If the learned, if I can
No,
demonstrate,
why do you have
my lord, because
to
the
argue to deposit
no,
27,000?
this is the my lord. I'm not arguing on deposit. If the cognizance itself is bad, my lord, then the order cannot stand. And I will demonstrate, my lord, from the order of Supreme Court, my lord.
No. Then you
In
file
case of the
separate
141, my lord, the
waiver, you
cognizance has
file
been
a
taken under
separate-
141.
I have gone through the orders of Supreme Court. You file a separate petition then. I'm very eager to grant you stay.
My lord, in
Subject
the in
to
that
condition
petition, my lord,
request.
that in the previous CA, my lord, the learned court was satisfied and there is stay was granted without
Wait.
deposit, my lord. That is one thing, my lord. If it is
You have given the order.
yes, my lord, I've given the order, my lord.
Okay.
My lord will peruse, if I may, my lord. It is submitted by Mr. Learned, say that we did such and such order passed by Learned Session Judge. In appeal number 51, the said appeal was dismissed, upholding the judgment of 25/9/2019 passed by the Learned additional CGM Kachar in NI case 83 of 11. My lord has got that line, second paragraph. By that judgment, the applicant was convicted under 138 and sentenced to undergo simple imprisonment and pay sum of rupees 1,38,000 only as in compensation to the complainant. He further submitted he has filed a connected revision petition mainly on the ground of cognizance was taken by the learned trial court under wrong provisions of law. The court will fail to appreciate that there are no legal enforceable debt. And on the part of the present applicant, he is also submitted the appeal has been heard ex parte without giving applicant an opportunity of being heard. Further submitted the
Yes,
appeal was,
please show me your petition.
my lord,
Your petition.
my lord. My petition is in the, my lord, wants to see the criminal revision petition, my lord, is referring to, my lord.
What is your ground in your petition?
My lord. My lord, in brief, my lord, I have stated. My lord will come to page number 5, my lord, where I have stated. And if my lord will turn a page before, in page number 4, paragraph number 2, I have stated what is the case. The accused petitioner beg to state that the petitioner has no connection, relation whatsoever with the relation economic developers organization as a society, hereinafter referred as society. The court is presumed it is in company, my lord, which is arrayed as accused number 1 in NI case number 83/11. The petitioner only peripheral association arises from the fact that he is a brother of Rajan Borcharji, which the order my lord has just read. Accused number 3. In the said case was that the relevant time serving as office bearer. His brother was serving as an office bearer. That is the only connection which he has with the entire matter. The said society, it is most respectfully pointed out that he did not sign the checks in questions which form the subject matter of NI case such and such. He was never a director or otherwise associated
All right,
with the-
all right. Then let us go to the judgment then.
My lord, please.
Findings.
My lord, please. My lord will come on that case too. Straight away, page number 75, my lord.
Yes.
My lord. Now, my lord, para number 1.
Hmm.
The prosecution case is that the complainant filed a complaint under 138 alleging relation. My lord has got that line.
Hmm.
Relation Economic Developers Organization is a construction real estate company, and the main business of the company is to purchase land and sell land plot wise, also to construct building with residential flats, commercial purpose, and gain profit and met maturity demand of such and such. Then he goes, head office of the company is at Srinagar Path, Lalgane, such and such. Above named president, secretary, city, executive city, and CMD of relation group, my lord. The allegation in the complaint is he's an CMD of relation group. Now that allegation has not been supported by any document. That I'll also demonstrate, my lord, and I'll also show how this CMD of relation group has been interpreted by the learned trial magistrate, my lord. So my lord has seen this paragraph. Then my lord will come to page number 77 and para number 3. On receipt of the complaint, an affidavit in lieu of statement such and such, CRPC, my learned president.
He was allegedly the CMD.
He was
His brother had issued a check.
allegedly of CMD of a relation group, not this company, my lord. That is the allegation, my lord. My lord, may I?
No, just a moment.
My lord.
But his brother has issued the check for the company.
Brother and one other man who has died, my lord. They had signed that check. That man I'll demonstrate, my lord. If I may
It's okay,
just
it's okay.
proceed to the page
It's
number.
okay, it's okay. I'll ponder about a matter.
My lord.
I'll ponder about a matter. I'll pass an order later.
My lord,
But
may,
you see, do you have to file an application for waiver of deposit of 20%?
my lord, that my lord will decide, my lord, because in this case, my lord, if the prima facie, my lord, if I could demonstrate that the cognizance order and the law of 141 has not been followed, then my lord will pass necessary order, my lord. Well, for a moment, may I draw attention of this honorable court to the judgment of 2025, my lord. Now, for a moment, my lord. Apart from this fact that the learned trial magistrate has proceeded to take cognizance under 138, whereas the cognizance ought to have been taken under 141, presuming it is in company, my lord. Now, my lord, we'll turn to page number of that 6, my lord, of the judgment, my lord, which I have handed over just now. Now,
Page number 6.
6, my lord. And my lord will turn to page number 5 for a moment, then the analysis starts from there. The learned court on the Supreme Court was analyzing the under 141, if the liability is there, how that liability has to be ascertained. Analysis of the finding, page number 15, my lord, page number 5, point number 15, my lord. My lord has got it. This court has consistently held that mere designation as a director does not conclusively establish liability under section 141 of NI Act. 138 read with 141 of.
I have gone through these judgments.
So, my lord, the point which I'm trying to.
I understand. I'll ponder about a matter, and then if I can
If my
pass
lord
an
pleases,
order,
my
I'll
lord,
pass an order.
my lord, there is no hesitation on my part to deposit, my lord. Let me be upfront about it, my lord. Only point which I'm trying to.
Why did you take such a long
My lord,
time?
because my lord, the reason is this, my lord, is because I do not have.
I'll ponder about a matter. I have heard you at length. I'll ponder about a matter. I'll go through everything in detail. even the judgments also, and I'll refer to.
My lord, on that case, my lord,
If
my lord
I
will
can
grant me
pass
the
an order
privilege of,
for stay, I'll pass an order for stay. You don't worry.
my lord, actually there is an arrest warrant has been issued against me, my lord. NBW has been issued against me, my lord. That is there, my lord.
No, against NBW, I cannot, I cannot.
My lord,
take
at least
the-
will stay the NBW, my lord, which has been issued against me.
Is
that is
there
what-
any prayer to stay there?
Yes, my lord, that my suspension of sentence is there, my lord. My petition for that, I have filed in separate IA, my lord.
That is what I am asking all the time. Did you file a separate petition?
Yes, my
for-
lord, IA had filed for the suspension of sentence, I have filed, my lord. That is 21612, my lord. I'm so sorry, my lord, I could not follow, my lord.
So it's okay, let me hear the PP.
Lordship, state is a formal party, Lordship, at this notice should go to the respondent number 2, Lordship. Because without hearing the other party, be difficult, Lordship, because he is against an impugn order where the cognizance has been taken
NWA
by the
issued
trial
against
court,
him.
Lordship. And also
And
may be called for in the
revision,
meantime,
we
Lordship.
can, in revision, we can suspend the sentence.
Yes, at least that can be, I may be.
It's only for 6 months, I think.
My lord, it's
As
1 year, my lord.
1 year, Lordship.
SI for 6.
Yes, my lord, 1 year.
Yes.
This is the last order which has been passed, well, NBW has been issued against me, my lord. 9/5, my lord, will produce the order.
So that
The-
is that that NBW order
But
pertains
you
not endless, Lordship.
deposit 27,000.
My lord, that my lord will, my lord, pleases, I will deposit, my lord, I am, and even my lord said,
This is what
my
I'm
instructions
asking
are not there, my lord, to, that is the
You
only
do not
point.
need to deposit, that is what I'm asking you. But otherwise, you have a very good ground of stay, and I'm willing to stay.
My lord will consider, my lord, because I cannot submit beyond my instructions. My instructions were not on this, my lord, so I cannot, if my lord direct, then my lord, I will definitely submit, my lord, I'll convince
You
you.
would have easily passed the order.
And
My lord will consider, my lord, on this. Yes, my lord,
for NBWA Lordship, there
My lord.
has to be a separate IA for that.
it is there.
I think it's not.
No, for suspension, because when I
It is a
filed this
separate,
case,
it's for suspension of sentence, that is for 1 year conviction. Lordship.
I only
And
got
where
to
is
know
the
this very recently, my
Full
lord.
NBWA Lordship, that is not an experience.
That, my lord,
Correct, is correct.
my lord, because what has happened, my lord, we had filed this case, and then we get to know about the NBW, which is what happened. Just recently we got to know, and I,
Stay of NBW, there has to be another application.
Yes.
my lord, because now
You rectify your application,
my lord,
you rectify your application, or you support your application,
with an affidavit, my lord,
of course.
my lord will, my lord, because my lord, the technicality my lord will give me some time, but till that time, my lord, if he is arrested, my lord, unnecessary, my lord,
Let the matter be fixed in the next week, Lordship, along with the IA.
my lord, I'm not,
Next week, first day.
Yes,
my
Lordship.
lord, by this, till such time, my lord, my NBW, my lord, will at least stay that, my lord. Otherwise, my lord, I may be arrested anytime, my lord.
No. I'll pass an order in this case, but I'll fix it for next week. Then you, first day Monday itself, not Monday, then maybe
My
Tuesday.
lord,
Lordship.
some protection, my lord. Otherwise, what my learned seniors will
I'll
not.
try my best to protect you in some manner, but if I cannot, then I won't.
If
I'll
my
have
lord
to
thinks
go by
that,
the rules and by the code.
There has to be a proper procedure to come for
I'll have to go by the rules and by the code.
waiving the NBWA.
I'll try my best. Let's see.
if my lord thinks that, my lord, if deposit of 20% will ultimately lead to, if that NBW can be state, my lord, then my lord will consider this also, my lord.
Next week, Lordship, any date.
Okay, let's see. I'll have to ponder over it because I'll have to go through the rules and the code and everything. And the act, not the code, the act, please.
My lord, on that case, shall I file an affidavit to this effect or in a separate application from this part, my lord? Because my IA was filed for
I
suspension
have to
sentence.
advise you,
My lord,
you mull over whatever you want to do, you mull over it. I won't advise you from this side. It's up to you. How to rectify or how to stay the NBWA.
For quashing of NBWA, there has to be a petition under
Yes, I think she's correct.
482 CRPC and BNS is 42.
Yes.
580/28 BNS is.
This order I will pass. And I'll try to be I'll try my best to give some relief, but let's see. If I cannot, then I won't.
does that give me, lord?
I don't know. I'll have to go through everything, the act, the rules, because right now I cannot, I'll have to read in details everything, your petition, your case.
Lord, on that case, my lord is fixing on the next week. On Monday, my lord is fixing. Or Because my lord, otherwise if I'm arrested, my invited, then my
Tuesday
lord,
on Tuesday,
my lord.
sorry, on Tuesday.
Tuesday on 17, Lordship.
Hmm?
17.
17th is Tuesday,
Yes, Lordship.
on Tuesday. 17th.
My lord, please.
Obliged.
No, no, মই আজি দুটামান order দিম. Item 8. Item 8.
May it please your lordship. This is a application under section 528 of the BNSS, the earlier 482 CRPC. So we have come by filing this criminal petition for quashing of the third FIR and the third charge sheet, lordship. So the petitioners before your lordships are directors of a company who are engaged with construction and other infrastructural work of NF Railway, and they were doing several works in Barak Valley from 2016 to 2021-22.
I think I have come across.
Yes, lordship has passed an order that was in respect of a second. Now they have find another person who was receiving bribe from me. So new persons came and third FIR came up, which is not permissible at all.
This is a
lordship-
separate cause of action, your lordship. I will come with the detailed objection in this regard. We have not yet filed objection.
I have no objection. Let them file. In the meantime, proceedings of the charge sheet and the FIR should be stayed. Maybe
That cannot be done. The cause of action.
I have
is
not
totally
argued by
different.
my case.
So let us file objection, your lordship.
No problem, but I want to stay because lordship will kindly come to the third FIR now. Let us, the first line itself says, page 24, the FIR part. This is the third FIR, lordship. It is submitted that a regular case was registered in CBI on 24/7/2023. That is the second FIR. White number so-and-so against some,
24.
page 24.
Where?
It starts from lordship, the FIR starts from page 21, page 21. So here lordship will kindly see occurrence of offense day 3A 2016 to 2023. Place of occurrence Silchar, Guwahati. Name Sunil Kumar. Then
You see, they want to file an
no,
objection.
no difficulty, lordship. Objection they can file, but I am praying for an interim prayer, lordship. I have an interim prayer here.
On that ground, they want to submit an objection.
Add interim prayer may be considered because the law is very well settled. The language of the third FIR and the second FIR are identical. There is a first FIR where I was arrested also. On the basis of the first FIR, they lost second FIR. Their lordship was pleased to grant me stay, and the hearing is now presently going on. On the basis of the second FIR, they file a third FIR. Whether that kind of multiplicity of FIR is permissible in law or not. If it is not permissible, then they have no reason to go for the third FIR. If they want to do anything, they can always file this additional or supplementary FIR, third seal.
Different cause of action at different point of.
That
time.
lordship will have to examine. That is the law. I'll place that law.
They can raise this objection. in
This is not the way to
trial.
argue.
They will get that benefit to raise this objection in the trial court also. These are the issue of the trial court. They can file a petition for getting it merged there.
Lordship will hear them, then I will argue my case.
No,
It's a
please
separate
continue,
cause of
please
action. We
continue.
need to file objection in detail.
Okay, let me, let him finish, then we'll come to you.
Yes. Now lordship will kindly see page 24, the third FIR. The first sentence, first paragraph. It is submitted that a regular case was registered in CBI on 24 July 2023, white number so-and-so against Santosh Kumar, the then Silchar so-and-so, Ambika Saw, Puspakanti and Bhartia. I am Bhartia. After registration of the case, searches were conducted at 13 places, including official premises of Bhartia Infra Projects Limited at Guwahati. During the search conducted at the official premise of BIPL at Guwahati, a statement ledgers in the form of group summary of Silchar office for the period 1 5/2016 to 30/12/2013 were seized by CBI. The said list contains the details of several public servants, railway officials who were associated with the project of the BIPL, have been paid bribes by BIPL in cash as well as in the accounts of the relatives during the period from 1/5/2016 to 31/7/2023. As per the said list, a total bribe undue advantage to the tune of 60 crores have been allegedly paid to the said public servants, railway officials of North Frontier Railway during the period. Investigation has revealed that Bhartiya Infra Project Limited has got the following work orders from Northern Frontier Railway at Jiribam, Imphal during the period 2016 to 2022. Series of works. And next page, Lordship will see, page 26. Investigation has revealed that the following railway officials of NF Railway associated with the projects of BIPL during the aforesaid period have been paid bribes undue advantage by BIPL in the accounts of their family members, friends, known from its bank accounts maintained at SBI and HDFC at Silchar and Guwahati. So these are the officials: Jitendra Jha, Rituraj Gogoi, Rampal, various persons who have received bribes. Mithun Das up to 7. Next, page 28. Investigation has revealed that Bhartiya Infra Projects Limited has utilized three bank accounts for making payments of the above said bribe, illegal gratification amount to the above mentioned public servants, employees of NFR Guwahati as a motive reward to get smooth clearance of its bill of the projects of NFR undertaken by Bhartiya. The details of the said bank accounts are given, 3 accounts. In view of above facts and circumstances, it is clear that Sri Rampal, the then Deputy CE, Jitendra Jha, P.I.U. Laskar, the then AXM, Rituraj Gogoi, Dhiraj Bhagavati, Manoj Soikia, and the then SSC, Sri Mithun Das, the then SSC P, had obtained the bribe illegal gratification in the above mentioned bank accounts of their relatives, friends known from Bhartiya as a reward for smooth passing of their contract bills. It is therefore requested that a regular case may be registered against so-and-so, including serial number 8 is Bhartiya. The role of above mentioned relatives, family members of public servants in whose bank accounts bribe illegal gratifications have been paid by MS Bhartiya, and also the role of the directors of BIPL who have paid the bribe for smooth execution of their projects may be investigated in the matter. So during the investigation of the earlier case, they have found that some more persons have received bribe. Now, Lordship will kindly come to the second FOI. Page 42. It starts from page 39. It starts. This was of 24 July 2023. Here, may I read it, Lordship? A case RC so-and-so was registered against Santosh Kumar, senior section engineer, page 42.
42, okay.
42, the main part of the FIR I'm reading.
Okay.
A case RC so-and-so was registered against Sri Santosh Kumar, senior section engineer, Northeast Frontier Railway, Silchar, and other on 4/2/2023 under section 120B of the Indian Penal Code under section so-and-so, so-and-so. During the search of the residential premise of Santosh Kumar, incriminating documents relating to income, etc. were found. Next page, Lordship will see. Paragraph 3. Investigation revealed that Santosh Kumar SSC during his posting at the office of Deputy CE, Northeast Frontier Silchar, had supervised works of Bhartiya Infra Project Limited. So-and-so, the company BIPL has 5 directors, the name of the directors. The directors, namely so-and-so, 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 including Avinash Bhartiya, led all the works relating to construction. Paragraph 5. Investigation revealed that Bhartiya Projects Limited is a contractor of Northeast Frontier Railway. It is involved in the construction and maintenance of railway infrastructure, including track bridges, tunnels, and stations. Northeast Frontier Railway awarded 106 contracts to MS Bhartiya Projects for the construction of the new lines and the upgradation of existing lines of the Northeast Frontier from 2000 till date. So 106 contracts during the same period. Investigation revealed that Santosh Kumar supervised the work of Bhartia while he was posted in the office of Deputy Chief Engineer Constructions Northeast Frontier Railway, Silchar. He had received for 75 lakhs as undue advantage from account number so and so, so and so. These are bank accounts. Paragraph 7. From the above, it is evident that Santosh Kumar, SSC, has received undue advantage on various occasions from Bhartia during performance of his public duty during the period of his office from 2019 to 2022. It is also found that Ambika Shaw and Puspa Kumari have abated Sri Santosh Kumar in receiving the aforesaid amount on a multiple occasions in their bank accounts on behalf of Santosh Kumar. In view of above, it may be registered against, a case may be registered against Santosh Kumar Senior so and so, Ambika Shaw, then Bhartia, Roman 5 is Bhartia, unknown persons, etc., through the directors and those who have signed the bribe related checks, so and so, so and so. So unknown persons is also there. Now, Lordship will kindly come to the first FIR.
So the time is different.
Same. Now here,
Continuing, it is in two thousand
Is it
nineteen,
not-
this is 2023.
this is, no, this is Lordship will see. These are all continuous. From here, it is Lordship will kindly see, page 25, 2016 to 2022,
Page 25.
page 25. Second paragraph,
Yes, yes.
2016 to 2022. That means what? The same works were going on, different persons received bribe. That is
At
their
different
allegation.
times. Mhm.
So for every persons to receive a bribe, can there be a separate FIR or not? That is the core issue. They have series of works. All the works are listed in all the FIRs. The persons who receive, one person they have identified initially. Now subsequently they have said unknown persons also received bribes. And during the investigation, lot of new facts came into light. And as a result, more persons' identity came into light, Lordship. So who have received? So for every person who received bribe for the same work at same station, whether there can be separate cases for which I have to face trial. And if there are separate cases, then conviction can be also separately given. So it is not permissible in law. For that, I have direct case, and Lordship was pleased to pick up this matter when the first FIR's matter is
That was similar.
identical. Now first, second Lordship stage, and now hearing is going on. They should fight the case properly there.
That appeared to be similar at least.
Here also, Lordship. Here also,
Yes.
only the persons who, more persons receive bribe. More persons receive bribe. So therefore, in that case, Lordship will have to examine. I would like to place page 277.
Page 277.
This is Lordship's order. Then I will come to the Supreme Court judgments. On 22/2/2024, paragraph 2, the petitioner Avinash Bhartia, Pawan Kumar Bhartia, so same directors, Lordship, who are before this honorable court today, filed this application under 482 of the Code of CRPC, seeking quashing of the affair and all proceedings emanating therefrom, including the charge sheet, if any, registered with CBI, dated 24/7/2023. This is what is the source of the present FIR, that is third FIR. The petitioners are the directors of Bhartia Infra Project Limited, a construction and infrastructure company incorporated under the Companies Act, which is office in Guwahati. The genesis of the case is the FIR dated 4/2/20, that is the first FIR against Santosh Kumar.
He was the person who has paid the gratification.
Who received the bill.
Allegedly.
Now,
Or received the
during the
gratification.
investigation, they found that beyond Santosh Kumar also, other persons also received.
Yes.
So that is the only addition in the third FIR.
Them.
In the third FIR, it has been found that Santosh Kumar received, fine, but 7 others also received in the same work during the same period. So,
I actually forgot. I forgot.
yes, Lordship, that is why I'm reading this.
Last year, beginning of last year.
Now,
so
I am quite, because the hearing is going on in another court. So Lordship considered all the laws and granted us the benefit. I am not shying away from the investigation or from facing the trial, but there should be one trial and one investigation. They cannot have separate investigation, which is a settled position of law. In this case, Lordship considered all the judgments and paragraph 26, Lordship will see. I'll place the similar identical judgments. In the light of the decisions of the Honorable Supreme Court in Asian's resurfacing and Niharika infrastructure, it appears that the stay can be granted till the next date. At this juncture, it is also not clear from the submission of both sides whether searches has been laid. In fact, that case also searches was laid. At this juncture, it cannot be ascertained from both the affairs whether the present affair is a second affair. A affair is not an encyclopedia. Without going into the details of the allegations, it cannot be concluded at this stage that the investigation is not fair and the subsequent affair has to be considered a second affair. However, further proceedings of CBI case so-and-so is stayed till next date. Meanwhile, call the scanned copies of the LCR, and if final report or if charge sheet has been not laid, call for the case diary. So Lordship was pleased to grant the stay. And now presently the hearing is going on. CBI is also arguing their case. We are also arguing our case. And page 24, the reference is 24/7/23. That is the second affair's basis. So whole FIR, third FIR, 90% of the content is from the second FIR. Only the few additional names are inserted who have received bribe. Now, if suppose, let us take this recent case, that Sonam Raghuvansh's case. If new persons are involved in the murder case, Lordship, then will there be a separate FIR or the same FIR will include him also? Suppose there are 5 accused persons killed dead. During the further investigation, another 3 names surfaces.
Okay.
So for that, suppose the Ananda Lodge persons are also involved, or some other persons from Indore or Guwahati are also involved. So can there be a separate FIR? The same FIR will do. So that is the law. I'll place the law of Amit Bhai Shah's case as well as the 2010's case. Lordship, I'll place the law. That is why I'm praying for stay of this case. The law is very well settled and the facts are very clear. Their whole third FIR from first line till the last paragraph, it is all based on the second FIR's investigation findings. Only during that findings, they found that another 7-8 officials of NF Railway have received bribe. So for every additional person who received bribe, can there be a separate criminal investigation? Or that additional findings can be merged with the findings of the first investigation and there can be a supplementary search sheet. That is the law. Earlier, the provision is 173(8), that when additional facts comes into light, then there is no bar in filing subsequent or additional search sheets. So they can do that. It is not that they are remediless or I am taking advantage of this situation. My only situation is that I am protected under Article 21, that there should be fair investigation, fair trial. And there cannot be multiple trials on the basis of same events when there is a sequence of events. And Lordship will also have to examine from the facts, which will come from the materials which will be called for, that whether the test of sameness can be applied here or not, whether these are consequence of events or not, whether this is a chain of events emanating from the same cause of action or not. These can be seen only from the materials on record. And that exercise is going on while the Honorable Court is examining FIR 1 and FIR 2 at this stage. They are also party, they are also arguing their case. We are also fighting the same case. In fact, my humble submission is that Lordship, I'll place the law also, that Lordship may be pleased to stay the proceedings. Let this matter also be clubbed with the other case, the other single case, so that the Honorable Court will be able to see whether there is similarity and sameness of facts and offenses in respect of the first FIR, second FIR, and third FIR.
But not at this stage, no? Stage, clubbing will come later.
Lordship?
Clubbing the cases together will come later. This is the preliminary stage.
It is a preliminary. Lordship, maybe that's why I have a strong case from the record which is placed before this Honorable Court today. The FIR, 2 FIRs, very clear is a third FIR says it from the investigation done in terms of the second FIR, that is 27 July 2023, we have found that Bhartia was conducting work in Barak Valley. They were executing infrastructure and other construction works, and the allegation is that they have paid bribe to some of the officials of NF Railway so that their bills are cleared smoothly. That is their allegation. Second FIR says Suresh Kumar received bribe. Now here they have said that another 7 persons also received bribe. First FIR also received bribe. So every additional person who is receiving the benefit or receiving the bribe from my client, there cannot be separate cases from the same events. The events is construction works from 2016 to 2023. The period is also matching. So now I would like to place Lordship. First, let me show 2013 6 SCC page 384. The first line of the FIR is itself sufficient. Paragraph 25 itu dia. Satu dia. Anju.
2013 SCC 3.
2013 6 SCC page 384, paragraph 14, 15 and 25. I would like to rely. I'm taking Lordship's time, but
It's okay.
as it is a case of interim prayer, Lordship, I have to place it. Paragraph 14. On the plain construction of the language and scheme of section 154, 156, 190 of the code, it cannot be construed or suggested that there can be more than one FIR about an occurrence. However, the opening words of section 154 suggest that every information relating to commission of an cognizable offense shall be reduced into writing by the officer of the police station. This implies that there has to be the first information report about the incident which constitute a cognizable offense. The purpose of registering an FIR is to set the machinery of criminal investigation into motion, which culminates in filing of the police report in terms of section 173(2) of the code. It will thus be appropriate to follow the settled principle that there cannot be two FIRs registered for the same offense. However, where the incident is separate, offenses are similar to or different, or even where the subsequent crime is of the same magnitude, it does not fall within the ambit of the scope of the FIR recorded first. Then a second FIR could be registered. The most important aspect is to examine the inbuilt safeguards provided by the legislature in the very language of section 154 of the code. These safeguards can be safely deduced from the principle akin to double jeopardy, rule of fair investigation, and further to prevent abuse of power by the investigating authority of the police. Therefore, second FIR for the same incident cannot be registered. Of course, the investigating agency has no determinative right. It is only a right to investigate in accordance with the provisions of the code. The filing of report upon completion of investigation, either for cancellation or alleging commission of an offense, is a matter which, once filed before the court of competent jurisdiction, attains a kind of finality as far as the police is concerned, may be in a given case subject to the right of further investigation. But however the investigation has been completed, a person is found to be prima facie guilty of committing an offense or otherwise, re-examination by the investigating agency on its own should not be permitted merely by registering another FIR with regard to the same offense. If such protection is not given to a suspect, then the possibility of abuse of investigating powers by the police cannot be ruled out. It is with this intention in mind that such interpretation should be given to section 154 of the code, as it would not only further the object of law, but even that of just and fair investigation. More so, the backdrop of the settled canons of competence of not only the investigating agency, but even the learned magistrate. The court has taken this view primarily for the reason that it would be opposed to the scheme of the code and would more particularly section 167(2) of the code. Now coming to paragraph 15. It has to be examined on the merit of each case. Whether the subsequent registered FIR is a second FIR about the same incident or offense or is based upon distinct and different facts, and whether the scope of inquiry is entirely different or not. It will not be appropriate for the court to lay down one straitjacket formula uniformly applicable to all cases. This will always be mixed question of law and facts depending upon the merit of the given case. That is why record have to be examined. Number paragraph 25. The first information report is a very important document. Besides that, it sets the machinery of criminal law in motion. It is very material document on which the entire case of the prosecution is built. Upon registration of FIR, beginning of investigation in a case, collection of evidence during the investigation and formation of the final opinion is the sequence which results in filing of the report under section 173 of the code. The possibility that more than one piece of information is given to the police officer at a police station in respect of the same incident involving one or more than one cognizable offenses cannot be ruled out. Other materials and information given or received otherwise by the investigating officer would be statements covered by the section 162 of the code. The court, in order to examine the impact of one or more affairs, has to rationalize the facts and circumstances of each case and then apply the test of sameness to find out whether FIRs relate to the same incident or the same occurrence are in regard to the incidents which are two or more parts of the same transaction or relate to completely two different occurrences. Here the works list are given. Same works I am giving bribe to, the allegation is that I am giving bribe to different officers.
Yes.
So the occurrence is same, the sequence of events is same. More persons are involved.
Down the time, down the.
Down the
period.
time, and they have given a long period, 2016 to 2023.
Yes.
And in one 2010 to 2021. The principle of sameness, Lordship will have to examine. If the case is not stayed at this stage, I will have to face the trial now. They have already filed a search sheet. Why should I, if ultimately Lordship decides to set aside the third FIR? So just saying that these are different occurrences, different facts, that will not be sufficient. That will have to be placed, the records have to be placed, and Lordship will have to examine it. I'll come to the other judgments, so it is more clear on those judgments. If the answer fails in the first category, the second FIR is liable to be quashed. Here it is a case of third FIR, Lordship. How they are harassing me. I know that the allegation is that I paid some bribe. But for that, I cannot face 3 criminal trials or 3 criminal investigations. And in one, I was arrested and I was granted bail also. However, in the case of contrary proof, whether the version of the second FIR is different and they are in respect of two different. Now, if we just for time's sake, Lordship, if we compare first, second FIR and third FIR, in the third FIR, they have narrated all the findings of the second FIR. Only addition is that few more officers are involved in receiving. Offenses are also same. Same offenses under the PC Act as well as the BNSS or IPC. So the first line itself says, it is submitted in a regular case was registered on 24/7/29. That is the second FIR. And these are the findings. All the works were given, the dates were given. And the new names surface, those names are the additional or the more persons who have received the bribe. This is the first judgment I am relying. Then I am relying upon Lordship. Amit Bhai, Anil Bhai Shah's case, 2013 6 SCC. 2013 6 SCC 348. This was a highly politically sensitive case.
Yes.
Here, paragraph 37, 38, and 2 more paragraphs, 58.2 and 58.3.
58 point.
Let us go to 37, Lordship, first. Paragraph 37. This court has consistently laid down the law on the issue of interpreting the code that a second FIR in respect of an offense or different offense committed in the course of the same transaction is not only impermissible but violates Article 21 of the Constitution. In T.T. Anthony's, that is the main case. In T.T. Anthony's case, this court has categorically laid down that registration of second FIR, which is not a cross case, is violative of Article 21 of the Constitution. The following conclusion in paragraph 19, 20, and 27 of the judgments are relevant, which read as under. Paragraph 19 of T.T. Anthony's case. The scheme of CRPC is that an officer in charge of a police station has to commence investigation as provided in section 156 or 157 CRPC on the basis of entry of the first information report on coming up to know that the commission of the cognizable offense. On completion of the investigation and on the basis of the evidence collected, he has to form an opinion under section 169 and 170 or 170 as the case may be, and forwarded the report to the magistrate concerned under section 173(2) of the CRPC. However, even after filing a report, if he comes into possession of further information or material, he need not register a fresh FIR. He is empowered to make further investigation, normally with the leave of the court, and when during further investigation he collects further evidence, oral or documentary, he is obliged to forward the same with one or more further reports, which is to import subsection 8 of section 173. From the above discussion, it follows that under the scheme of the provisions of section 154, 155, 156, 157, 162, 169, 70, and 173. Only the earliest of the first information is regarded to be the commission of an cognizable offense, satisfies the requirement of section 154. Thus, there can be no second FIR and consequently there can be no fresh investigation on receipt of every subsequent information in respect of the same cognizable offense of the same occurrence or incident giving rise to one or more cognizable offenses. On receipt of information about a cognizable offense or an incident giving rise to a cognizable offense or offenses, on entering the FIR in the station house diary, the officer in charge of a police station has to investigate not merely the cognizable offense reported in the FIR, but also other connected offense found to be committed in the course of the same transaction or the same occurrence, and file one or more reports as provided under section 173. A just balance between the fundamental rights of the citizen under Article 19 and 21 of the Constitution and the expansive power of the police to investigate a cognizable offense has to be struck by the court. There cannot be any controversy that subsection 8 of section 173 CRPC empowers the police to make further investigation, obtain further evidence, both oral and documentary, and forward a further report or reports to the magistrate. In Narang's case, it was, however, observed that it would be appropriate to conduct further investigation with the permission of the court. However, the sweeping power of the investigation does not warrant subjecting a citizen each time to fresh investigation by the police in respect of the same incident, giving rise to one or more cognizable offenses, consequent upon filing a successive FIR, whether before or after filing of the final report under section 173(2) CRPC. It would clearly be beyond the purview of section 154 and 156 CRPC, nay, a case of abuse of the statutory power of investigation in a given case. In our view, a case of fresh investigation based on the second or successive FIR. So in our case, it is successive FIR.
So you see that that in the second FIR case, the charge sheet was submitted.
Yes, it was
So
submitted.
you are suggesting the supplementary charge sheet should be submitted in that case.
Or
with the
times-
First FIR.
In that case, the first FIR I was arrested. In the first FIR, they did not charge sheeted me. They found that I had, along with Tribeni Constructions, I also paid bribe. So for that, they lost a second FIR. So one more persons who were bribing. So for every additional person bribing, what they are doing, they are filing separate FIRs. So that is been under examination now, whether that is required or not. In Amit Bhai's case, when Sohrab,
Yes, yes.
Lordship knows.
That is a
Then
long story.
during the third conspiracy, another person was killed. In that case, no. First two persons died. One died on 25th, one died on 29th. Investigation done, search.
Other case that.
Yes, yes.
That case is.
Yes, I do not want to repeat. So another person was who was also considered to be a witness of the case. He was died in an encounter much later.
Yes.
All these cases were clubbed together.
Yes.
So that is the ratio of what I am trying to. Now coming, this is the from T.T. Thomas, and what in this case the Honorable Supreme Court says 58, 2 and 3. In fact, my case is much better than Amit Bhai's case. The present case. 58.2, the summary. Various provisions of the Code of Criminal Procedure clearly shows that an officer in charge of a police station has to commence investigation as provided in section 156 or 157 of the code on the basis of the entry of the first information report on coming to know of the commission of the cognizable offense. On completion of the investigation and on basis of the evidence collected, the investigating officer has to form an opinion under section 169 and or 70 and forward the report under 173(2). Even after filing of a report, if he comes into possession of further information or material, there is no need to register a fresh FIR. He is empowered to make further investigation normally with the leave of the court, and where during further investigation he collects further evidence, oral or documentary, he is obliged to forward the same with one or more further reports, which is evident.
In the T.T. Anthony's case.
Absolutely.
Yes.
So that is the settled position. That is why, Lordship, today I am praying that the proceedings may be stayed. Lordship will examine, apply the test of sameness, and there is another test. Yes. And in Arnab Goswami's case, Lordship, 2020-14 SCC.
You have referred to that case last time.
Arnab Goswami I did not refer, but all subsequent affairs were set aside.
Yes, Arnab Goswami's case.
I am not saying that I will shirk away from the.
Give it to me. You can.
Yes. So my humble submission is that, Lordship, I will not trouble at this stage with all the judgments. The law is well settled
You can
and
give the Arnab
it has
Goswami's case.
passed the test of time. All this law. Why the CBI is committing the same mistake on and on, I am not sure about that, Lordship. But it is sheerly a case of violation of the Article 21 and 19 in my favor. And also, it is a case of sheer harassment.
I think I'll hear no objection also.
Let them file objection, but
No,
Your Lordship.
She'll submit orally.
Yes, I would like to submit, Your Lordship. This is a matter relating to contract work. And various contract works being called time to time, that is in the way of calling of expression of interest. Nowadays, it is known as calling of expression of interest. Earlier, it was known as floating of the tender. So there are various tender, and in this department, there are always renovation work, renewal of the work is going on, new work is also going on simultaneously. There is no doubt. So because of the works are going simultaneously, so there are different tender work. And there are different transactions. Because of that, when there is a different tender work or expression of interest has been called, whenever the work order is allotted, there would be a different agreement, work agreement for the various work. Maybe it is a small or maybe it is a big work, but there would be a different agreement for the separate contract work. And when there is a different agreement, definitely there is a different transaction. Maybe the same department, maybe the same person is having the competent authority, is having the authority of giving a work order for the various work. And he has the authority to call for the expression of interest. It doesn't mean that the same person is there, same date is there. On the same date, two contract work may be called. There is no bar calling two different contracts. And since there are two different contracts, definitely there is a two different transaction. The person, the competent authority or the officers may be the same, or the supplier or the contract worker, whosoever it may be, he may be the same. There is no bar in giving an expression of interest or getting a tender. One person may get one tender, one person may get 10 tenders. It is depending upon their qualification to apply for the tender proceeding. Yes. And there are different tender agreement. To that effect, I am apprising your Lordship. Kindly see page number 62 of one charge sheet and page number 93 of another charge sheet. So in page number 62, it is clearly given the work order contract agreement, period involved. So this is for the tunnel 6C 2014 dated so and so, so and so. And second is W362 construction, GD bomb, T-pool blast, so and so, contract period is so and so. If we'll go on comparing with another charge sheet, which my learned friend is saying that there should not be a different charge sheet. While filing from the same transaction, if further investigation is required, IO always put one line that further investigation is going on and we may be permitted to
Page
file
number 62 is-
supplementary charge sheet.
Page
If it
number
is on the
62
same
is
transaction.
this contract.
Beg your pardon.
You are referring to page number 62, one contract.
62 and then 93.
So this page number 62 is another contract with another agreement. That is
Yes,
what you.
yes, another. That
And
is
page
going,
number
that is why
93
different
is
charge
another
sheet.
contract
It
with
cannot be merged together. It cannot be
Page
merged.
93.
Page 93. Kindly compare your lordship. This is a serial number from 1 to 9, 1 to 12, and this is from serial number 1 to 18. And all contract number, date of agreement, and the place are different, which is very vital. Person may be the same, supplier may be the same, contractor may be the same, but it is a different contract, different agreement, different work order. Date of completion of work order is also different. It cannot be merged together. Then kindly see your lordship, page number 163. Page number 163 of third charge sheet. That is the work order. Then 164 covers 3 work order. There are only 3 work order for the different site, different date of agreement. How it can be merged together? Nature of work is different. Somewhere it is a renovation, somewhere is a new work. And it is all based on the measurement book. Money are paid to them, bill are cleared based on the measurement book. Measurement book is
Yes,
there,
yes.
field officer is there. He used to measure the work. For different agreement, there are different measurement book. It cannot be same.
Yes, yes.
And for payment of money, there should be a different head for payment of money of those bills. For new work, there is a different head. For renovation work, there is a different head. For repairing work, there is a different head. And this is their document which they have annexed, which were not shown to your lordship, which is the vital document in the charge sheet. And the relied upon document will speak the truth that the work order is different, agreement is different, date of completion of the work is different. Officer may be the same. My learned friend is giving the example of Raghuvanshi. It is the same transaction. So if there is any investigation, further investigation is required, their IO always give a line, put their line that a further investigation is going on. So we may be permitted to file, they take the leave and permitted to file a supplementary charge sheet. This is not a question of supplementary charge sheet because officers may be the same. Court is one and the same. I am coming for one case, I am coming for other case. There may be 10 cases in the same court. Does it mean that all the cases could be merged together? Answer would be no.
Yes.
And my learned friend has not shown this work order and the date of agreement and the date of completion. It is very much there. It is 63, page number 63, page number 91, page number 163. It cannot be said as a same. And that is why different FIR, because it is arising out of different expression of interest, different tender, different agreement. That is why different FIR. How it can be merged together? One or work order, which is for new work, another work order for repairing of the work. How both 2 tender can be merged together?
Okay.
This cannot be. Otherwise also it is not possible. Person may be the same, officers may be the same, contractor may be the same.
Just one question.
Yes.
So according to petitioner side, that this work is relating to railways work, the same cause of action is the same. So one work given in series, in a series at different times. So
No,
it come, the
no,
cause of
Lord.
action is the
The
same.
procedure is that there are number of works, number of expression of
That I
interest. are
understand
there.
because contracts, we also used to give
Yes,
contracts.
yes.
As district judges, we used to.
Yes, yes,
whenever
yes. So
can
different, yes,
every
yes,
leave
yes.
it always.
Yes.
So that I understand. But that is what that petitioner side is
But
saying.
they are
So I'm
saying
asking
from
for
the,
clarification.
but they are saying if it would have been arisen from the same work tender or same agreement, then there could be one FIR. But since it is from the various different contract agreement, maybe the same person.
Yes.
I'm taking two contract for new work, old work. So I have to sign a different 10 agreement I have to sign. So there would be a 10 cause of action. It cannot be a same transaction. The moment agreement has been entered for different work, transaction is different. The moment work order is allotted for different work, the transaction is different. Here the question involved is transaction, not the same one.
All right.
Transaction. And in one charge sheet, for different transaction, they cannot pay for filing of supplementary charge sheet. Had it been of the same transaction and there is for some reason, investigation could not be completed, then IO take the leave to file a supplementary charge sheet. But since there is no question of incompletion of the investigation, for one expression of interest, one tender, one agreement, one allotment of work, one FIR.
So this
Maybe the
expression
department.
of interest is tender nowadays.
Yes. Nowadays it is called as expression of
Okay,
interest.
Expression of interest.
They float the expression of interest. Those who are having the interest, they will file
So
their.
different expression of interest.
Yes, tender and it is subsequently it is known as expression of interest, calling of expression of interest. So from this chart, it is well revealed that the contract are different. Time may be the same. There is no issue. Timing is not the factor because all works are going parallelly. Time is not the factor. Transaction has to be seen whether these are arising out of the same transaction. And if it is not arising out of the same transaction, there would be a different FIR. Had it been from that same transaction, there would have been a prayer for filing a supplementary charge sheet. So one person may be involved in the number of offenses. There is no bar, same section, various offenses, various cause of action. So at this stage, it cannot be granted. Otherwise, the trial would be stayed. In that event, the basic motive of speedy trial will be. And if at all it is required, I may be permitted 2 days to file some ruling with regard to the Supreme Court because it is a new case allotted to me.
Yes.
So
Ruling
today
you can
only I
submit,
got
yes.
it. So if your lordship may extend for 2 or 3 days time given to me,
Yes.
I can apprise your lordship with regard to the same transaction, and if it is not the same transaction, how the different FIR can be filed.
2 days time. Let us
To this
submit a
time, I have
ruling.
no difficulty. Now, it is a self-defeating argument they are making. Lordship will kindly come to page 44. It starts from page 39. The second FIR. 24/7/2023. Lordship will kindly mark this date. So 24 July 2023. Now Lordship will kindly come to page 42 where the main body of the FIR starts. Now coming to page 44, paragraph 5. Their argument is that for separate works, separate cause of action arises. Paragraph 5, Lordship will kindly see. Investigation revealed that Bhartiya Infra Projects Limited is a contractor of NF Railway. It is involved in the construction and maintenance of railway construction infrastructure, including track, bridges, tunnel, and stations. Northeast Frontier has awarded 106 contracts
Yes.
to MS Bhartiya for the construction of new lines and upgradation of existing lines in the Northeast region from 2000 till date. So they have encompassed all the work in this FIR. So whether these new 6 works which they are showing in third FIR, is included in this 106 contracts or not?
This is the first or second affair?
This is the second affair.
Now I'm getting confused.
This is second affair, and Lordship will kindly come to page 24. The first line of the main body of the third affair. It is submitted,
Which page?
page 24 now. It is submitted. Have Lordship got it? Page 24.
Yes.
This is the third affairs body. It is submitted a regular case was registered in CBI on 24/7/2023. That is the second affair.
Hmm.
Here, Lordship will kindly come to the last line. From the bribe was here after registration of the case, second paragraph. Searches were conducted in 13 places, including official premises of Bharti Infra Projects Limited at Guwahati. During the search conducted in the official premises of BIPL and Guwahati, statement ledgers in the form of group summary of Silchar office for the period 1/5/2016 to 30/12/2023 were seized by CBI. The said list contains the details of several public servants, officials who were associated with the project of BIPL have been paid bribes by BIPL in cash as well as on accounts of their relatives for the period during 1/5/2016 to 31/7/2017, 23. So this covers the earlier period of 2000 till 2023 July. So they have encompassed everything, all the transactions, not a separate. And next page. And as per the said list, a total bribed undue advantage to the tune of 60 crores have been allegedly paid to said public servants, railway officials of page 25, Northeast Frontier Railway during the period. That period is 2016 to 2023. The second affair says 2000 till 10 to 2023. Now further, investigation has revealed that Bhartiya Infra has got the following work orders from the NF Railway at Jiribam, Imphal during the period 2016 to 2022. So which is also included in the second FIR. What are the works here? At Kamgaon, construction of railway station yard, then protection of tunnel portal, balance work of construction of single line BG tunnel, fourth, construction of RCC retaining wall, fifth, construction of foundation and substructure, sixth, construction of balance work of artwork and art cutting. So according to them, what my learned friend was just submitting, for every work, there should be a separate FIR. This is what they are saying, separate this expression of interest, separate work order, separate transaction, separate settlement order, separate measurement books.
Yes, yes.
So what they are saying, it is self-contradictory. So the second affair consists of 106 number of works given to Bhartiya from 2010 till 2023, 106. So in that 106, these 6 works were also included. They have to prove before this honorable court that these 6 works do not comprise of those 106 number of works. In second FIR, in paragraph 5, they have categorically stated 106 number of works were allotted to Bhartiya from 2010 to 2023 July. So they have to prove before this honorable court that these works, 6 works. So what I am trying to emphasize and satisfy this honorable court, that they have every right to investigate regarding these 6 works also in terms of the second FIR.
Yes, but they must be included. They must be merged together, which she is saying that they cannot be merged together.
No, what she is saying that these are all separate transactions. But second FIR is relating to 106 number of work for a period from 2010 to 2013. 20, that means for 13 years period, they included 106 works which are within the ambit of investigation. So they found some officers received some bribe in one case. They found that in some other officers were also involved and receiving the benefit and bribe from Bhartiya. in that view of the matter, Lordship, the law is well settled that they have every right to investigate, they have every right to charge sheet me also, but not in separate proceedings,
Yes.
in single proceeding. So in that view of the matter, in my humble submission, Lordship may give them ample days of time. I have no objection. Let them produce all the records, let them produce all the judgments, let them file a.
Let her file two, just, she want to submit two
But
judgments
till
against.
that day, Lordship, I
against
may be
interim stay.
protected. I may be protected, Lordship.
So let her-
In the meantime,
Protection may not be.
a
granted,
fresh
Your
cause of
Lordship.
action
The-
because
2-3 days.
Otherwise,
no,
was-
2-3 days also, I have no difficulty.
Otherwise, also FIR is the summation of some deeds or misdeeds. Only after getting FIR, that is why a machinery starts for investigation. And during the course of investigation, whatever the things reveal, accordingly the charge sheet are being filed. And admittedly, there 106 awards are there. That means when 106 construction work award is there, so they are at different transaction, at different point of time, may be parallelly given. Date may be the same. So it doesn't mean that if it is not reflected in the work order in the FIR, all should be included in the same. FIR file just to initiate the government machinery to investigate the fault or offenses. And only after offense investigation, facts will reveal. FIR is always summation. It is an information. There's something wrong is going on. It has to be investigated.
Monday she'll submit the judgment. Let her
Judgment, no
submit the
difficulty,
judgment.
Lordship.
We-
Only
let-
thing is
let
that,
us an order.
I will.
no difficulty, Lordship. I'll come and I'll argue also if required.
No, it's okay.
I have done my part.
Go to her
Judgment.
Monday it may.
Only thing is that, Lordship, in the meantime, if the trial court issues a summon, then fresh cause of action will arise. That is the only concern. So till Monday, no further proceedings of the case. On Monday, Lordship will pass an appropriate order, detailed order.
This matter is investigated by New Delhi branch, anti-corruption branch. I have to take the instruction and get certain information because it has been newly allotted to
So
me.
when you.
So I need, it is not possible
when
on
you
Monday
submit
because
the
tomorrow is
Judgments. Then we will allow
Thursday,
you
by
some time.
Thursday, by Thursday or Wednesday.
Then he has submitted his prayer. I'll have to ponder over the matter then. Because he is submitting that new cause of action may arise if summonses is issued. Summons have not been issued.
No, till now it
Charge
has.
sheet has been filed.
Search sheet has been filed. We have said challenge the search sheet also. And when they have investigated the second affair, they collected
then-
all my
then
records.
If charge sheet has been filed, then there
Then
would be
there
a
is
problem
no
if
question of,
summons is issued.
No, there will be issue
Cause
or
of
someone,
action.
someone will make
Even
issue.
someone is, the question
The
of.
cognizance has not, may not be taken till now. So that is why, Lordship, the proceedings of the church seat in terms of the church seat may be stayed at this stage till the next date. I'm not,
Charge sheet-
indefinite way also I'm not praying. A date may be fixed next week, convenient to my learned friend.
You're not.
And till that moment, Lordship, no further proceedings in that search.
When someone has not issued, that means trial has not yet started. So there is a no question of staying the trial. Unless and until someone is issued, all accused will come and they will get the copy of the charge sheet. Thereafter, only the trial starts.
No. See, I will ponder over whether I'll give us, whether I'll grant a stay or not, I'll ponder over it. His submission is that if cognizance is taken, then then another issue will come.
If cognizance, even if cognizance will be taken, here the petition is to quash the charge sheet, not to quash the cognizance. If charge sheet has been quashed, then the question of cognizance or subsequent event does not arise.
Why the trial court should waste their time?
There
If
is
the
no
church seat
question
is
wasting the-
set aside later on. They
It
should
is
not
not
waste their
question
time. They should
wasting
not
time.
put me into harassment also. It is-
When clearly.
Nothing is,
so
heaven is not going to fall, Lordship,
a
if it is
different,
stayed.
different cause of action, different work order. And when a charge sheet has been filed, someone has not yet issued, that means trial has not yet started. Where is the question of staying the trial?
Okay. I'll ponder over it. Let me see. And then which paragraph you are referring to in Arnab Goswami's
We have
case?
indicated.
Huh?
Paragraph 30 to 37 and Lordship 65, 61.5.
Okay, it's written.
In my humble, it is a fifth case for grant of stay, Lords. from the materials, which is
When
before this
transaction
one.
is not one and the same,
That
it is not a fitness
106,
for
106, they have included in their second round of investigation.
This they can raise there.
First one, it should say.
If any transaction is same, they can file petition, it can be merged there. Not here. This is the question of trial court. Because transaction is totally different.
All right.
The date may be fixed, Lordship.
I'll fix a date.
Lordship.
I'll fix a
I
date.
leave
because
it to your Lordship.
She wants to
File objection also and
objections.
For objection, that is a different. I am paying for ad interim order.
Yes, yes.
And if they are standing counsel, so they should produce the judgments. For judgment, they don't have to get instruction.
Given to me yesterday only, that is why I am not in a position. However, I have
I fully
prepared
appreciate that, no difficulty. Let it be on Monday or Tuesday, Lordship, for consideration of the ad interim
Wednesday or Thursday.
stay. Ad
Wednesday
interim
or
stay,
Thursday,
I am
Your
praying,
Lordship.
Lordship.
Because I have to get instruction from.
That is a regular for, it will take 2 weeks, 3 weeks time.
No, I am not asking for 2 weeks. Only up to Wednesday.
So ad interim and then thereafter
So
a
because
regular
only
stay
charge
may be
sheet
heard.
filed. Even someone has not yet issued as per my submission of brother. Then what is the problem when trial has not yet started?
That is why Tuesday or Monday, Lordship may fix.
For trial, only 1 month or 15 days dates are given for starting of the trial. Only after framing of the charge, the trial would start.
Hmm?
Now the summon has not yet been issued, so there is no question of trial. Why they are pressing for that? And once the charge sheet has been filed, that means court has taken on record, cognizance has been taken. Only after taking the cognizance, someone would be issued. This is the procedure.
All right.
Deeply obliged.
Much of.
No. 45 minutes of this.
May I please? My lord, I have agreed, my lord, by filing a complaint. Kindly see, my lord, page 73.
Yes.
Page 73. My lord.
Mm.
My lord, petitioner, my lord, obtained loan, my lord, from Yes Bank. Here, my lord, from Yes Road branch, petitioner, my lord, inhabitant of the Guwahati, my lord, he applied for loan, my lord. Here in this branch, my lord, Guwahati branch, he was granted, my lord, loan.
Mm.
And that loan was, my lord, to be classified as NPA. For that, my lord, the bank filed, my lord, original application before the tribunal, my lord. I have enclosed there, my lord, application also. It is at page 13. It is at page 13. It was filed on 28 March 2024.
Mm.
My lord, inside the complaint, my lord, inside the application, kindly see page 37, which is, my lord, a ground number 8. There are 5 number of loan account, my lord. One of them page 37. This is the, my lord, the original application filed before the DRT Guwahati. 5 loan account is mentioned, my lord. Rupees 13 lakhs and so. CVL number so and so. My lord, I am confined to, my lord, CVL number amount rupees 3,91,403.69 paisa under account number CVL 0481010411767.
Okay. 25 lakhs. 25 lakhs.
Yes.
But that place is at Calcutta, Kolkata.
My lord, how
Case
they,
has been registered in
my-
Kolkata.
yes, debt recovery tribunal for debt amount file here, my lord, is pending. And my lord, they file another case, my lord, in Calcutta before the magistrate court. No cause of action, no offense committed wholly or partly in West Bengal or Calcutta. Still they, my lord, have made their branch, they file there. And my lord, interesting point is this, my lord. Till this month, my lord, they are, my lord, deducting from my account their EMI. My lord, even after filing this petition, my lord, they deducted. Kindly see the CBN number.
Which page?
My lord, it is after filing, I obtained, my lord.
Oh, no, no, no.
After filing this petition.
No, 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 no. After filing, you have to file along with the
After
petition.
filing this petition, this I obtained, my lord.
No, no, no.
My
You'll
lord,
bring it, you'll bring it afterwards through the affidavit. Through
My
additional.
my lord, I have enclosed also, my lord, this, my lord, statement, bank statement.
Hmm.
Page 72 is the bank statement, my lord.
So this is a complaint case.
Complaint case. My lord, three things involved here. First of all, for recovery of debt amount, they filed DRT here, which is going on, still going on. My. And
So
my
do you
lord,
have the judgment
after
for
this,
staying?
after,
Do you have the judgment for staying proceedings in outside the state? There's a judgment.
my lord, kindly see three things. First of all, they filed debt recovery tribunal here for recovery of amount.
I
And
need some help
second,
from your side. Do you have the judgment for staying proceedings outside the state? This okay, the jurisdiction is Kolkata High Court. So you are asking for staying, interim staying, aren't you?
quashing.
Yes,
Because
yes.
my lord,
Quashing, I know, but this is at the motion stage.
yes.
So
Three
you,
things, my lord,
aren't you asking for interim stay?
my lord, three things is there. They first of all they file DRT. Second, they regularly staying, my lord. Can you see page 72?
I understand. They're taking the EMIs.
After declaring, my lord, NPA.
Hmm.
And third, my lord,
No, that is,
they file a
that is why I'm
complaint.
asking. Do you have the judgment
No.
for staying, interim stay of
No,
proceedings?
no,
or-
apparently, my lord, it cannot be like this, my lord. They one hand they filed the debt recovery tribunal. They also deducting from my account. They're taking the
Then we
EMI.
clear it finally then. I need the judgment. I need some help from your side. Otherwise, I'll fix it.
No, no,
You-
provision is there. Provision is there in GNSS. Now, can you see provisions?
That is what I'm asking.
Provisions, my lord, are there. Section 197 of the NSS.
Hmm.
Place of inquiry and trial. When it is every offense shall ordinarily be inquired into and tried by a court within whose local jurisdiction it was committed. Nothing has been committed in West Bengal or Calcutta. Everything
No,
here.
no, I'm not asking that. See, you are from this case is registered in the Court of Judicial Magistrate, Kolkata.
Kolkata.
So there is a judgment of the Supreme Court and some judgments of this court also that
Okay,
I can quash the proceedings of that.
Okay, my lord, on Tuesday, my lord.
Yes, that's what I'm asking. If you give the judgment, then I can very well proceed.
Okay.
Learned Counsel Mr. S. Chauhan has prayed for adjournment. List the matter on 19. I'm sorry, on 19th.
What?
May I please, Your Lordship? In this case, Lordship, the NBW and PNA issued against the petitioner, Lordship. Lordship, kindly come to page number, Lordship. And out of same incident, Lordship, and two two FIR, two case has been instituted against the petitioner. Kindly come to page number 11, Lordship.
Page 11, yes.
11, Lordship.
Mm.
May I read?
Yes,
Lordship?
please read.
Today fixed for necessary order so and so and business PS regarding the bailor of Kashem Munshi. The brief fact is that the Kashem Munshi stood as a bailor for a accused person, namely so and so, and we are allowed to go on bail rupees 15,000 each of this case. And Rani Kata PS so and so under section 366 so and so. And land documents submitted by the Kashem Munshi were sent to the Rani Kata PS for verification. My lord, in this case, Lordship, and he appeared as a bailor, Lordship, and he submit some documents. And subsequently, the Honorable Court is called for report from the police and circle officer or through police, Lordship. And as per the report, Lordship, these documents was found fair. But as my lordship, that I have submitted the land documents, Lordship, kindly come to page number 20. And that documents already been on record, Lordship, part of the record, Lordship. Kindly come to for a moment, page number 21, Lordship. And Lordship, he is the original Pattada, Lordship. And these documents has been submitted. It is a part of record, Lordship. And my little submission, Lordship, and earlier occasion, Lordship, and 2-3 dates, Lordship, he engaged over telephone advocate, Lordship, and he did 3 dates, Lordship. And this petition was allowed, but subsequently, otherwise he was not appeared, Lordship, physically before this court. So in the meantime, Lordship, the PN, NBW and PN is issued, Lordship. Right now, Lordship, then he is ready to cooperate, Lordship, and only for recall this, Lordship.
NBW and PNA.
Lordship.
Have you annexed the last order?
Lordship, and kindly come to page number, Lordship. Page number 35, Lordship. Page number 30. Last. Oops. May I read, Lordship?
Yes, yes.
Today is the date fixed for SR and
This is 2022.
Lordship.
Now the recent order?
Recent, Lordship, and I'm coming, Lordship, and this order, this case is filed, Lordship, and in the year of 2022.
Okay.
Last part, Lordship. Page number 36, the accused person could not be found. Let this case be filed until further order, Lordship. So that is why. So, my lord, let me, Lordship, and he is a 64-year-old person, Lordship, and a very clear, Lordship, but he is ready to appear, Lordship. Only this was my prayer, Lordship. And the 65 years, Lordship. So, and all the documents is in the part of record, Lordship.
My lord, here, Kasem Munshi has stood as a fake bailor, my lord. Fake bailor, my lord.
I know.
He stood as a fake bailor, my lord.
What is his cure? What to do with him now?
My lord,
This case has been filed against him.
my lord.
We'll-
PNA, when NBW issued, thereafter PNA issued, when he has not appeared, my lord.
Yes.
You also examined, my lord. He also not found.
Actually, he
So
was
this
not,
case against him
he was not
filed.
appeared, Lordship.
Executing officer of Sirang is directed to appear before the court for examine next date fix. You-
Why not? Why not?
Examine and discharge.
That it has been proved. PNA has been proved.
My lord. Thereafter it was filed, my lord.
Let me, Lordship, and appear, Lordship, and face the trial, Lordship. Otherwise, this case is.
Yes, you appear and face the trial.
Lordship,
PNA has
only-
been proved. It cannot be kept in abeyance now.
Lordship, PNA.
NPWA could not be executed. It is in the pending file.
But Lordship, he's a permanent resident, Lordship, and 65-year-old person, Lordship.
My
But,
lord, let him
someone-
appear for within 10 days, my lord.
Lordship.
Court below will consider as per law, my lord.
Yes.
That is the-
Now I cannot.
My lord,
A PNA has been proved
my lord,
that NPWA cannot be kept in abeyance now.
my lord.
No, I'm
You
not,
appear.
Lordship, appear, Lordship.
I'll-
For 10 days time may be given, Lordship. I learned it from only
10
NBW.
days time, yes.
Stay may be, Lord.
No. NPWA, you see, PNA has been
PNA also proof.
executed.
Execute.
Lordship, and sometime, Lordship, police submitted report on the basis of police report, Lordship, and the PNA has been executed, whether, Lordship, and sometime, Lordship, Honorable Court is well aware, and he is a permanent resident, and he is a joint family, and 65-year-old person. How can, Lordship?
My lord, even if he is
Only
the
for this-
permanent, my lord, he
Only for that purpose, Lordship, and against for this case, and he evading from the village or somewhere else.
I can pass an order for him to appear, but I cannot give him bail.
Lordship, otherwise, before your Lordship, and
You can approach for anticipatory bail through another application because PNA has been executed.
my lord.
I cannot,
Yes, yes.
and this order has been properly passed. If you're contesting the order, then it's okay. I can pass any order, that I can pass an order for you to appear. You appear, I'll give you 10 days protection, you appear.
Yes, yes.
Only 10 days
Yes,
protection.
yes, yes.
But and I'm not keeping NBW in abeyance. It is kept in the pending file
Mm,
after execution of the PNA
Any protection maybe also I will appear, Lordship, 10 days, within 10 days.
within 10 days.
Lordship.
That will be for that forgery case, no?
That means that Lordship, otherwise forgeries will not come, Lordship, and that because, and his.
My lord, whatever he has
His re-
submitted documents, my lord,
Already
all,
part of
all
record.
are fact, my lord.
Part of record, Lordship, but I am.
Whatever part of that may be part about verification, after verification, it is found that they are
Okay, you
fact.
appear, but you may be forwarded to custody. Even if you're 65, you may be forwarded to custody. I cannot help you. Okay, you appear. Only 10 days protection. Thereafter, the court will pass.
Lordship, obliged.
Third learned counsel, Mr. F. Hawk for the petitioner.
And also, Lordship, and another submission, out of same incident, Lordship, two case has been registered, Lordship, and another case already been granted, Lordship.
What granted?
Protection, Lordship, NBW and PNA, Lordship, and out of same incident.
But here PNA has been executed.
That is this order, Lord, and out of same, Lordship. And one is here, appear now this is PRC and this is here. Out of same fact, Lordship, and he was a.
No, see, those I'm saying you. NBW and PNA are still in force. Here it's not in force.
It has proved.
It has been executed.
Lordship.
So
10 days protection, Lordship, anyway, Lordship.
this is different. This case is different.
Marcy maybe.
Third learned counsel, Mr. F. Hawk for the petitioner. Qasim Munsi, who has filed this application under section 528 of the BNWS 2023, with prayer for recalling the NBW and CNA issued against the petitioner. Heard Mr. B. Sharma, learned addition PP Assam. The PNA, it is the annexure.
Last order, my lord. Last page.
35 and 36.
36, my lord.
Annexure 5, no? The annexure 5 of the petition are the orders are passed by the learned trial court. Post of order in connection, learned trial court in connection with CR case number 9 of 2021 under section.
The section, Lordship, 193, 196, 200 and 467 and 468. Page number 18, Lordship.
190.
193, 196, 200, 467, 468 IPC. Page number 18, Lordship.
18, my lord. Page 18.
The order dated 10/11/2022 clearly reflects that the PNA was executed and the order of attachment was returned back to the court as no property, movable or immovable, was found against the petitioner. Full stop. The order dated 5/12/2022 in connection with the above mentioned case CR number 9 of 2021 clearly reveals that the IO was examined and
EO
was executed. On the basis of the evidence of the EO, this case was filed against and submitted that that the order has been correctly passed by the learned trial court and interference of the order is not warranted. I've considered the submissions at the bar with circumspection. It is submitted on behalf of the petitioner that the petitioner has been falsely implicated in a case of providing fake documents as a bailer, whereas on the contrary, the petitioner had provided genuine documents and he is not liable to the alleged offense. It is further submitted that the petitioner is 65 years old. The petitioner is willing to cooperate with the trial brought up against him although the allegations are not true. Full stop. So the petitioner stood as bailer for an accused who was booked under section 363, 376-D, 302, 201 of the IPC. I have considered the age of the petitioner and also the submission on behalf of the petitioner that the petitioner is willing to cooperate with the trial in connection with CR case number 9 of 2021. তার আগত I have considered 302201 IPC লিখিলা না and the accused and the accused Sri Pusu Baski, PUCHU Baski, Modern Besra and Makta Mandi are at present absconding, full stop. I have also taken a pragmatic view, full stop. The petitioner is directed to appear before the learned trial court within 10 days and cooperate with the trial. No coercive action to be taken till then. In terms of the above observation, this application stands disposed of.
JMFC Sirang Kajolgaon Lordship.
Likita learned trial court.
JMFC Sirang Kajolgaon.
So he stood as bailer
Lord.
for these people.
My offense is also 376D,
And
302.
302201.
My lord.
My lord, my submission is otherwise all the record documents is submitted part
But
of
he is
record lordship.
accused of that offense.
Or that, but he is the bailor, my lord, in this case. No.
Deeply obliged, lordship. Obliged. Obliged.
May I please, Lordship?
Hmm.
This is a particular case of a cybercrime where the negligence of the customer.
Lordship, I am appearing for the private respondent number 2, victim. Lordship,
Notice has
from
not yet been
whose
issued.
account?
Notice has not been issued. I don't know, Kebit or Wakalnama has been filed.
No, your Lordship, we have already filed the Wakalana today itself, Lordship. That is there, Lordship. Further, Lordship, the main order which has been challenged by the petitioner company.
Let me place my case, my lord. For my landed. May I please, Your Lordship? This is a case while due to the fall or negligence of the customer, this is response number 2. Now the bank has been ordered to refund the money. There's a cybercrime for whether it's a cybercrime for or whether the negligence that I'll come to my lord. If Your Lordship may come to straight away to the FIR by the response number 2 at page 119.
This HDFC Bank.
Yes, my lord.
Then recently there was another, I think, very nationally famous fraud committed by an employee of the HDFC Bank. It just come
happens.
up in the news also.
But it happens, but now my lord, there's no.
This is very dangerous. We
Not
also account in the HDFC Bank.
My
It's not.
It may happen.
Private
It's
bank
happening in the other banks also. My lord. That is a true fact. But here, but it's a different.
Even in Axis Bank,
Axis Bank also, yes. But now it's a different case. My lord. It's a cybercrime.
but HDFC Bank was having such high shares.
Lordship,
such a
nowadays
reliable
private
bank.
banking,
What is wrong with the bank now?
My lord, this is a different,
With the
totally
employees.
different case, my lord. There I'll place.
nowadays, Lordship, private banking become more dangerous for the society and for the account holder. Even after the repeated order by the trial court.
Until, a few years back, it was having the highest shares in
Lordship,
the market, share market.
Yes, Lord.
My lord, if I may, my lord, that diligence of the customer has also been also has to be there. If I may, my lord. Well, Lordship may come to the FIR, my lord, at page 119, my lord.
119.
Well, I may come to straight away to 120, my lord. I'll start his FIR.
Will hear on admission or what?
Motion.
This is at the motions.
My lord. I'll just place it the record now what has happened, my lord. I'm just placing out the facts, my lord.
You wanted an interim stay.
My lord. Now, what has happened, my lord, there is the customer number 2 is involved in some trading businesses where he himself approached, appeared before the bank, and he has submitted the amount of rupees 50 lakhs. Malad, which your lordship will find at page 51. It is not a case of a cyber fraud. Malad, he himself have come and deposited the amount. 51, at page 51 is the acknowledgement receipt, and page 52 is this check, Malad.
He can be involved in trading business.
That is,
There are semi-registered trading business also.
yes, Malad, that's what I'm trying to say. Yes, now what has happened, after he has deposited the 50 lakh, that has been flushed out by the same, the place where it was deposited, which your lordship will find in the statement of account at page 55, Malad. Page 55, it starts the statement of account to where the amount was deposited.
Hmm.
And now, on the operative portion, where your lordship may come to page 68. 68, my lord, if your lordship is getting 1, 2, 3, 4, 5, on the 6th column, my lord, transaction.
Hmm.
Yes, your lordship got it. No?
Hmm.
Page 68, my lord, on the 6th column, my lord, on 14/5/2004, he has deposited an amount of 50 lakhs.
Hmm.
Which your lordship will find on the right-hand side in the middle. Page
Yes,
68.
Yes.
50 lakh he has deposited.
Hmm.
After depositing the 50 lakhs, what has happened? It has been flushed out to whom it was given. If your lordship may come to page 74, my lord. At the 2, 3,
Yes, page 74, yes.
74, my lord, on the last transaction, that is 14/5.
Yes,
Before
14/5, yes.
14/5, the last transaction of 14/5.
Hmm.
Your lordship may see the balance on the right-hand side of the statement account.
1,700.
1,700. So what has
Where
happened?
did the money disappear?
Money has disappeared. Through other transactions. The account to which it was transferred, to who himself he has deposited, has been taken out through different transfer. And again, what on the next day, again some amount has been credited through other. It is, we are not denying that there has been a fraud, the fraudulent transfer on this account. We have also filed the FIR to the FIR. Now, with regard to the response number 2 is concerned, he has deposited money 50 lakh on 14, and on the same day, all the money was flushed out. And your lordship may correct, so it's 1,700. And on the next day, on the 15th, again some other money was credited from the other sources. And on 17th, we got the information from the police to debit freeze the account. So on 17th freeze, the amount was around 8 lakhs something. So we immediately debit freeze the account. And after the debit freeze of the response number 1, there are 27, my lord, multiple attachment order from different states. I mean, there's not a single state which has not been involved in this crime. We have been, so in this matter, the account has been freezed. And there has been court order. Other court order, even your lordship will find at page 44. Message order from the court. Page 44.
Yes.
These are court orders and other. Wherever even they have, the other courts have also been asking the bank to return the amount to the victims. There are several other courts. This is one of such, from Rajasthan, Mumbai, Bangalore, Kolkata, everywhere. Now, the thing is, my lord, in which property now, this is the money. Here is the case, my lord, where the customer have himself, and before the SGM London, SGM 2, while passing the order, did not consider the bank. The bank was not taken into consideration. The statement of account was not followed. Simply by this, the police have only tracked it was transferred to this and this account. That is only the thing, and that account has been freezed. But here the question is the amount which was deposited by the response number 2. He himself came and deposited. It was flushed out. He came, it was reported 3 days after.
So let us list this a matter for admission and dispose it of.
No, that's not, we do not have any objection to return the money. If this amount is to be returned to the response number 2, there will be multiplicity of litigations all over in all the state, because we are not able to comply in any of the directions. So these petitions mostly have a guidance to whom to comply. And here's a case, where I'll
You're asking for quashing the order.
Yes, for the order, quashing the order, and also for the guidance.
Which order? Which page?
That page.
Order dated 4/6/2024, last year passed. Annexure 4, page 39 notes.
39 to 40. This is one order. We have also appeared before the magistrate court. And we have also placed our documents. At page 39.
Short date will hear it.
And also, we have, what happened, we have also placed the materials before the learned court, but the learned court, since she doesn't have the power to review the order, so that was not considered. At page 106, we have placed everything. This is our difficulty. And if your lordship may see even in the FIR, it has been said that whether there is an involvement in the bank, in the police report, nowhere in the police report, it has been said that the staffs have been involved.
So we'll find out, we'll.
That's
take
what,
the
that is
records,
what, my lord.
We'll
In the
go-
meantime, my lord, state a proceeding till the admission. We'll take a short date, my lord.
This-
I'm ready to argue.
This is a complaint petition, isn't it?
Lordship, this is the not a complaint
Yes, yes.
petition. Lordship, brief
FIR.
Yes, my lord.
FIR on the basis of the FIR, Lordship, the Jimma petition was filed before the trial court. And on a learned trial court, after considering the material facts and records, after calling the police report, they passed this order dated 4/6/2024 for handing over the amount, which was freezed by the cyber police. And thereafter, Lordship, another order was repeatedly was passed by the learned trial court after considering all the material facts and records. And as per the notification issued by the Honorable Guwahati High Court, that is notification number 60, that is reflected in the order dated 19/11/2024. In spite of the repeated orders, Lordship, they are not releasing the other bank have already been refunded the amount, which has been frauded with the private respondent number 2. But so far as the SDFC is concerned, time and again, they are only lingering the matter before the trial court also, for only to keeping that amount, the freeze amount. They can't want to refund back to the victim.
My lord, that amount
And
doesn't.
when they are ready to furnish the indemnity bond.
That
they are
amount
not
doesn't belong to the
finally
respondent number 2. It all my humble submission. The bank, which whatever amount is remaining in that account, has been the money of the other sources, which they have also filed a separate complaint, my lord. Here is a case where the respondent number 2 has paid the money and it was flushed on the same day. And it is not the fact that banks are involved. He himself have admitted that he is involved in trading. The banks do not have privy to the transactions of the customers, my lord. They may transfer whatever money they want to transfer. But the 50 lakh, and he has transferred actually 50 lakh. Now he is asking for an amount of 6 lakhs.
Yes, Lord.
6 lakh is not his amount, my lord. Even I have shown by the statement of account, the amount which was deposited by him has already been flushed out on the same day. And this whatever amount is remaining in that account, fraudulent account, is the account of it is the money of the other.
How can you say this is a fraudulent account?
Yes, Lord.
Well, fraudulent amount, that is what has been happening. I am not saying it's a fraudulent account. The police are saying it's a fraudulent account. That the multiple transactions have been going, and that has been also been freezed till now because there are 27 multiple attachment orders from different states, my lord, not only in Assam, my lord, from Gujarat to Tamil Nadu to Maharashtra to West Bengal. That has been freezed. Many complaints are there. And regarding that, we do not have any allegation of giving the money. But the question is whether he is a rightful owner of that property. He has transferred 50 lakhs. And it was flushed out on the same day through the statement of account. It is not that the bank involved in it. He himself came to the branch and he has submitted the money, deposited the money to 50 lakhs. Well, now how can banks take a note of every transaction, my lord? After the complaint, it was been freezed, debit freeze. But the amount which is remaining in the that account doesn't belong to the respondent number 2. That is my submission. If your lordship thinks to give the account, there will be multiplicity of litigation against the bank all over India, because we are not able to comply. That is my humble submission, Manu. And if your lordship may look at the negligence part, there has been order from this.
You see, when this case is before me, maybe this account, maybe, I don't know, whatever you are submitting, I don't know.
My lord.
Maybe you were not aware of the transaction taken, going on between all these places, between the parties. So maybe that money has been deposited and flushed out by them, whatever it is. If I grant stay,
No.
then it will take effect to the other cases also.
Well,
So I'll decide it finally. I'll decide it finally. Let us call for the scan copies of the child code record within a short week, within a short time.
Manu,
Within next week.
Manu, if on
Lordship,
25th,
kindly see
Manu,
the conduct of the bank authority, Lordship. They have challenged before your Lordship the order dated 4/6/2024.
Yes, my lord.
That is Annexure 4, page 39.
Yes,
And subsequently, the order dated 19/11/2024, page 106 only. And they are taking the plea of the other court's order, Lordship.
Yes, I have
And
challenged
kindly see
because the
that
investigation was not done properly, my lord.
Nationalized bank, that is this.
Lordship, the fraudulent.
Let us call for the trial court record we will decide it finally on that.
My lord,
date of
I'm not saying,
admission.
whether it did, we are not denying that if your lordship thinks that the money belongs to him, my lord, we are.
The trial,
We will call for the scan copies of
My
the
lord.
transport record. We'll fix this matter for admission, whether the record arrives or not, we will
My lord.
decide it on that date. sir.
My lord, my lord.
Okay.
My, any date.
Both the parties are represented. Call for the scan copies of the transport record. List this matter into admission column on 23rd June.
23rd, I will be out of station, Lord.
My lord, 25th.
23rd June, Lordship.
But 23rd even, I'll be out of station, my lord. I'm sorry, my lord.
23rd
Subject to the convenience of my learned friend.
My diary.
26, my lord. I'm sorry, next. 26.
Yes, can be 26 June.
26 June.
Yes.
In the meantime, a copy may kindly be served on us, Lord.
Yes, I will, sir.
Petitioner to furnish a copy of the petition to the respondent.
Private respondent.
And an
number two,
extra
Lord.
copy to the,
The private respondent number 2.
well, with an extra copy to the respondent number 1.
Yes, yes. And extra copies to be furnished to the respondent number 1.
My lord. 26. All right.
Ready?
A small matter, my lord.
Okay.
In a DV case, my lord, what has happened, my lord? Your lordship, it's between the two ladies, my lord. The petitioner is a lady.
Hear and dispose it of.
Yes, petitioner is also a lady, respondent is also a lady, my lord.
Okay.
In the family, my lord.
He is my elder brother's wife and I am the younger brother's wife. Having the same share household.
That is
Problem
that is
remains is
disputed,
that
my
the
lord.
only the legal point which your lordship has to admit is that the very same point which they have taken in the quashing, they have already filed an application to that effect in the learned trial court, my lord, which is pending. Now a matter, a dispute, my lord, what I'll place is that a disputed question of law cannot be decided in a 482 application. Because, like, my lord, she herself filed a DB case wherein she got an interim order that she should not be ousted from her matric share household. Very same order I am also
You have
having against my.
Yes, my lord.
You have both settled a dispute, no?
No, no,
Yes.
no,
Not settled.
not that set, not that set.
Okay. Then
Now,
you
my lord,
just stated that you have
Yes,
settled.
it is all.
Then, my lord, she took a order against her husband that she should not
Jethani,
be-
Jethani.
Yes, she is the
No,
Jathani, I am the
of course,
Torani, yes.
Of course, yeah.
She is the Jathani.
Amendment, full stop. Ready to reflect the name of learned counsel, Miss P.B. Bodley as legal aid counsel for the petitioner. This is the matter on 25th June.
Highly obliged. It might not reach item 32 and 33.
32, 33.
Yes, and because they're domestic violence cases, and the matters are stayed, very urgent. Might not reach, last date also it was a left over. So as early as possible with the court's convenience, and it may be fixed. It's for orders only. We completed our dusty services and it's only for orders.
Let's see, the 32, 33.
32 and 33.
32, 33.
And related matters also.
These are for order?
My lord, yes. And both are the same aggrieved person actually. They connected matters. If they can be joined together, that would have been a bit of a convenience for the court as well. Same cause of action.
I'll just check the office note. Tenant has received a notice on behalf of the respondent.
We have completed dusty service on both, for both
You
the
have completed
cases.
dusty
We have completed dusty service. His tenants have received, and now they have also received in another matter, they have appeared. So we delivered the notices for the 3 cases together.
You have mentioned in the affidavit.
Yes, we mentioned. We didn't mention that we delivered for 3 cases. We didn't mention that part. But we have mentioned that the tenants have received it. And the tenants have been living for more than a year now. We tried to complete the dusty in Guwahati. He didn't receive. He doesn't receive the phone call. Otherwise, we'll have to send e-summon next time.
Where is the affidavit?
It was not tagged perhaps, but it was the office.
Oh, not tagged, no? Affidavit nahi diya nahi, no? Tag nahi hoga.
Affidavit is there.
Affidavit is there?
Yes, but they forgot to put the tag
Notice.
on the affidavit.
Okay.
But the affidavit is there.
Okay. এইটো গোটেইখিনি ক্লাব কৰি লিখি দিয়াচোন 32 and 33
32 and 33
separate নালাগে separate কে লিখি দিয়া learned council miss
but if it can be clubbed together because
we'll list it together only learned council miss your name ASK is present for the petitioner and has submitted an affidavit relating to the service of notice on the respondent
respondent number 2
Respondent number 2. Vicky Kumar is a tenant.
Yes.
The notice has been received by the tenant of the respondent. So tenant is not proper service.
But nobody, he doesn't live there. He lives in Guwahati. He doesn't want to receive the thing in Guwahati. He doesn't want to make phone calls. Next choice is only the summons that is prevalent in the, and we try to make the service through CGM court. Even that didn't work. So this matter has been going on for more than a year now, only for service. But the tenant has delivered, that we know. Because there were 2-3 tenants living there and he's been living there for more than 1 year. Immediately he made phone call also. So he is received. And his parents have already expired.
It is submitted that the respondent is
and
not
that is his
residing
permanent address.
in the given address.
That is the permanent address of the respondent.
Comma, although the address is the permanent address of the respondent, full stop. The respondent resides in Guwahati. Full stop. It is further submitted that the tenant has informed the respondent about the notice. This cannot be called as proper service. You will have to advertise. You do not have the money, no? Do you have? You are the wife, no?
And she is a victim of a lot more. I had submitted before your lordship earlier.
But this is not proper service.
The lordship may suggest a way. The last option I have thought about is the e-service through WhatsApp. The e-service is what the
But the
BNSS...
rules are not framed here.
The rules are not framed. But the e-service is the one that we really need to work on.
Paper publication, she's a desolate wife.
I will take care of the expenses.
Legal Service Authority.
I'll take the expenses. I'll bear the expenses.
Notice to be issued to the respondent to substituted mode. Any possible through paper publication.
And if e-service also may be mentioned.
You can take.
We have to begin somewhere because it is given in BNSS.
E-service rules are not framed. No?
Rules are not framed, but we have to start somewhere. Your lordship may have a beginning somewhere because he is available online and he's messaging also. We tried to solve the matter outside the court. He is not willing to solve it.
Information Technology Act, if we start under by electronic mode, a big amount to
Service also.
Yes, as per BNSS as well.
Yes.
Yes,
Or
both-
other
both-
substituted
both-
mode.
both
Or
may
other
be mentioned.
substituted mode. এনেকে লিখি দিয়া। And both the cases,
Both the case.
same. You have filed an affidavit in both the cases?
Yes, so we have filed an affidavit in both.
All right. Obligation and other substituted mode. And then if you submit to e-service, then.
We'll
okay.
try to get all the printouts and everything. We will, because we know that he is available online. He's just not picking up the phone when we call him.
Okay.
Much,
Is
much.
the matter on 18 July?
18 July, 18 July. Much.
দুইটা এনেকে লিখি দিবা।
Humble prayer before Lordship, item number 37, your Lordship.
Mm.
May take up at the last item, if not bridge, your Lordship, because
Okay.
37.
Can take up as a last item. Item number?
Case 14. The affair. Marital. 1 foot affair.
Everybody is present, no?
Everybody present here. The police officer is there.
Or you represent the police officer, no?
That case, yeah. And there.
All right.
Case 14 is the affair. Affair 3623 with reference to subject matter, I have the honor to state that today at Swensu, while I along with the accompanied staff was on Naka checking, student Devhal Tiner 1 Ashok Leyland Dampar being Swensu was coming from Tinsukia side. On being instructed to stop the dumper, is stopped. When we examined the dumper, we found the dumper was loaded with crude oil in a separate chamber, which was concealed by sand in the above. Accordingly, we informed the oil, seized the dumper and apprehended the driver, Hargozudi Gogoi. Swensu address. So kindly take necessary action to proceed. And case is registered under Section 379 IPC. It is Section 32B of the PTPP Act, Financial Damage to Public Property Act, and also 7 of the Essential Commodities Act. I am not the FIR accused. Moreover, your Lordship, after his arrest, Hargozudi Gogoi, the police has obtained the CDR of the SIM card, however, and found the involvement of 3 persons, one Hemanto Gogoi accused, Rubul Moran, and Bimal Dahotia. Nothing has involvement and connection with the petitioner. Omid Borshekia, but the IO of the case submitted charge sheet showing the petitioner as absconder accused. After that, till date, petitioner is not aware of that case and arrested the accused persons. And with the charge sheet, after submission of charge sheet, then trial court, Chief Judicial Magistrate, your Lordship, Tinsukia issued summon to the petitioner. After receipt of summon, he has come to know about this case, and after inquiry in the matter, and he obtained the certificate copies and found that charge sheet submitted showing the petitioner absconder accused. In fact, the petitioner is a reputed businessman, your Lordship. A well-known businessman, your Lordship. I have stated paragraph 7 of my petition. What type of business he has dealt with? Page 6, paragraph 7. I have annexed the document also. Page 6, your Lordship, paragraph 7. Your Lordship. The petitioner is a well-known business proprietor of ABS Enterprise, deals with installation of GI connection for supply of pipe natural gas in the domestic and commercial houses, and he's a proprietor of RJ Bricks Industry and also proprietor Omid Dhaba. He's a reputed businessman of this. It is not suspected maybe someone has falsely implicated him for his business rivalry, and I have annexed the document of this business in Annexure 4, 5, Annexure 4, page 30 to 15. I have annexed the document, and page 52, documents with brick industry, and page 56, and is relating to his dhaba.
Page 52 is his what?
Page 52 is agreement for his brick industry or proprietor of brick
Oh, brick
industry.
industry.
And order of page 38 is supply of gas, your Lordship, gas pipeline, page 38 order from the department. He is the proprietor of ABS Enterprise. He is a deputed businessman. I have also verified that nothing, he is not involved in any criminal and there is no relation with that accused person. And he is falsely implicated, therefore he is person. Moreover, your Lordship, 379 cases, 370, your Lordship, no.
For 379, there may be a public complaint by private complaint, but in this case, the police has lost the FIR, Your Lordship. Informant is the police officer, and there is no information from the other side, Your Lordship. You have to satisfy 378, and moreover, you have to, I have not the FIR if it's known purpose. Only maybe I have found, I've checked the LCR, I found that the accused person said that there is another person, he also deals with the crude illegally. That must is, that's why I was submitted the charge sheet. There is no connection in this case that accused person is not known to the petitioner, and there is no involvement in connection in this case. He is falsely implicated in this case. Therefore, I have filed this petition for quashing the person in respect of the petitioner, not for the other year.
Okay.
And in this way, I have relied upon judgment, Your Lordship. The quick statement cannot be glad other that is corroborated by other relevant documents connection, Your Lordship. To punching judgment, Your Lordship, note 2021 for SCC 30.
This is 482's judgment or already decided cases judgment?
Decided case.
Huh?
To punching judgment, I have relied, I have not bring and another judgment, Your Lordship.
Quashing judgment will be required, but if it is final hearing, then see, 482 is not a mini trial.
It is a quashing, it is against the, Your Lordship, acquittal, against the quashing against the acquittal. Then the, Your Lordship, the Union of India and Supreme Court has dismissed this petition.
Against acquittal.
Acquittal, yeah. Against acquittal.
This will not help.
Okay, then Your Lordship, gone on the LCR, you have verified the LCR, if you have found any amendment and passed judgment. I have found is nothing is there. Only statement that is that there is another person, he dealt with business. That is enough. And it cannot be convicted, and then on the basis of that statement, Your Lordship, why we face the trial in 379 case? He's a reputed businessman and he's not involved in this case. There is no linkage with the accused person. Nothing is it.
Yes.
Subjectivity.
Lordship, here this is the case of theft of crude oil, Lordship. So why they have what they have done, they have made a separate chamber, secret chamber in their vehicle, and they are transporting it, Lordship. And thereafter, Lordship, this person's name has been implicated by the co-accused person. And they have stated, Lordship, that all these persons they have mentioned 4 persons, all they are of same party, they are doing this business, Lordship. This is, Lordship, that I have checked my Lordship, will find it here, Lordship. Lordship. But Lordship, there are Lordship. Lordship here. আৰু ময়ো ফোন কৰা নাই মৃণাল দহিতিয়া দুলীয়াজনৰ অমিত বৰফুকন বুলি এজন আছে আৰু ইহঁতে একে পাৰ্টিৰ মানুহ হয় বিমল দহিতিয়া হেমন্ত গগৈ একেলগে মই এই কামটো মোৰ ইমান 1 লাখ টকা পালো ইয়াতে মই এই তেল চুৰৰ লগত ডিব্ৰুগড়ৰ দুলীয়াজনৰ অমিত বৰশইকীয়া বুলি এজন আছে so he has been specifically implicated one of the arrested person has specifically implicated regarding his involvement Lordship so Lordship and trial has already been started Lordship those yet Lordship charge not framed Lordship but Lordship someone has been issued to the persons Lordship all the persons
charge has not been framed
not framed
yet. And on the other hand, Lordship, regarding the judgment of Tufan Singh, Lordship, and all Lordship, they are during for a part of investigation, Lordship, on they can take the plea of while they are seeking bail, Lordship, that is different, Lordship. But Lordship, while after filing of charge sheet, Lordship, when there is sufficient evidence found against this person, Lordship, and co-accused person's statement is specifically implicated, in that case, Lordship, this is not a case of quashing, Lordship. To that extent, Lordship.
Charges have not been framed?
Not framed.
Not framed. 17 is fixed of hearing on charge.
Let the charge be framed, Lordship, because without framing of the charge, Lordship, we don't know what the...
Sending back, rejecting the petition, let the charges be framed.
Yeah, after Lordship may be set. Because after charge also, they can also...
plea at the time of framing of charge.
Verified on online, and 17 is the date fixed for hearing on charge.
I'm rejecting it. I'll have to reject it.
Because I have not found it. The only statement that another person is there in the name.
No. His name has been specifically mentioned, Lordship, that I have mentioned.
He will be acquitted definitely, but not quashed. Case cannot be quashed. Third learned counsel. বেছি লম্বা নহয় ছুটি হ'ব। Third learned counsel, Mr. Item number কিমান হয়তো?
16. Yes, yes, Islam.
S. Islam for the petitioner. 16.
16. You pause this, madam, not from me.
Your name is not in the cause list.
In the case is there, but my junior's name is only my name is.
Learned counsel, Mr. S. Islam for the petitioner, Omid Borsokia, who has filed this application under section 482 of the Code of Criminal Procedure within bracket CRPC for short for quashing the entire proceeding of PRC case number 79 of 2024 under section 379 of the Indian Penal Code within bracket IPC for short bracket close read with section 3 within bracket 2 within bracket small b of the PDPP Act and section 7 of the EC Act corresponding to Bordeaux Police Case Station case number, Bordeaux PS case number 87 of 2023. It is submitted on behalf of the petitioner that the petitioner's name is not mentioned in the FIR. Full stop. The FIR unfolds that on 30/06/2023 at about 3:45 p.m. during Naka checking, the informant SI Dhruvo Prasad Prakash Boisya intercepted a dumper of Ashok Leyland make. মই যেনেকে ডিক্টেশ্যন দিছো তেনেকে লিখি দিব দেই, চেঞ্জ নকৰিব। Bearing registration number AS 09AC 4834 approaching from Tinsukia side. Full stop. On checking the dumper, the police team found that it was loaded with crude oil in a secret chamber, which was concealed by sand. Full stop. The driver, Sri Khargojyoti Gogoi, was apprehended in connection with this case. Full stop. It is submitted on behalf of the petitioner that during investigation on during investigation, after seizure of the SIM card of the driver, 3 names
Page 5, para 5.
3 names, para 5, no?
That's
Of the petition.
page 5, para 5.
Three names, three accused persons, three names, three accused persons, namely Sri Hemanto Gogoi, Sri Rubul Mora, and Sri Bimal Dohotia were found involved in smuggling of crude oil. Full stop. It is further submitted on behalf of the petitioner that the petitioner is a reputed businessman. Full stop. He is the owner of a dhaba, a brickfield.
Dhaba and Brickfield and also ABS.
Brickfield, KILN, huh?
And ABS Enterprise. And also Messrs. ABS Enterprise deals with supply of.
And Messrs. ABS Enterprise.
Deals with supply of pipeline gas, natural gas.
Huh?
Supply of pipe natural gas to domestic and
which supplies domestic gas. Domestic gas to the customers. Through pipe connection. Annexure 4 is the work order of MS ABS Enterprise. Annexure 5 is the
Agreement for RJ Bricks Industry.
agreement of the brick
RJ Brick Industry.
of the MS RJ Brick Industry, and annexure 6 is the registration certificate.
Not registration,
Or
the
is
certificate.
the dhaba is the certificate, is the certificate to substantiate that the petitioner is the owner of Omid Dhaba. Full stop. It is submitted that there is not even a whisper implicating the petitioner. Full stop. The charges has been laid on the ground that the co-accused have stated that another person has been involved in smuggling crude oil. Full stop. On suspicion, the petitioner has been charge sheeted in connection with this case. Full stop. It has been held by the Honorable Supreme Court that on the statement of co-accused, comma, any person cannot be held liable or convicted in connection with a criminal offense. Per contra, the learned additional PP has submitted that the scanned copies of the trial court reveals that charge sheet has been laid against the petitioner. Full stop. There were materials against the petitioner, and a prima facie case against him was found, which owing to which charge sheet has been laid against the petitioner. Full stop. The petitioner is complicit and he is involved in smuggling crude oil. Full stop. The offense is of a serious nature, and the proceedings of the entire PRC case number
79 of 2020.
79 of 2024 cannot be quashed at the initial stage because charges have not yet been framed. I have considered the submissions at the bar, and I have also scrutinized the scanned copies of the trial court record. Full stop. The petitioner, at this juncture, a mini trial cannot be held. At this juncture, this court is hesitant to invoke the inherent jurisdiction under section 482 CRPC. Full stop. The merits of this case are not brought to the fore as this case is pending for trial. Charges are yet to be framed, and the petitioner has the liberty to raise this issue at the time of framing of charges. In this initial stage, it cannot be preempted that possibility of conviction appears to be remote and bleak. Full stop. It also cannot be preempted, PREEMPTED. It also cannot be preempted that further proceeding will be an abuse of the process of the court. Full stop. This case is relating to an offense of public property, full stop. At this juncture, petition is rejected. At this juncture, petition stands rejected. As the,
At
ठीक
this stage.
at this stage, petition stands rejected. Okay.
Item 26. Item 26.
Please, your lordship,
Hmm.
this appeal has been referred challenging the judgment dated 14/5/2025 in session special case number 178/2022 court, whereby convicted the appellant under section 8 of Procedural.
Delay on 24/7/2018. Thereafter, my lord, FIR was registered on 2/8/2018. And my lord,
Complaint case was filed on?
my lord, it is filed on 24/7/2008. And it was
And the
registered
incident occurred on?
2/7/2008
Okay.
and registered on, my lord, 2/8/2018. And my lord, medical report, my lord, typed copy, my lord, page 18, annexure 2. There is nothing, my lord, in the medical report also. And my lord, FIR, my lord, they are translated part FIR at page.
May I please, your lordship? Steps have been taken on 24/10/24. Upon order number 5/18/20 and 21. And as per the office note dated 2/6/25, your lordship, the notice has been received. We are yet to file the substitution petition, your lordship. Maybe 4 weeks' time may be granted.
Okay.
As far as the actual order was passed, immediately passed.
It is already abated, my lord, as far as
So
their
as far as
provisions of law.
that, that appellant is concerned, bill number 1.
Then they'll have to file other petition.
And the other.
Some of the respondents, as it was submitted,
It is abated already.
because
So they have to file this
You'll have to-
restoration petition.
We are yet to receive information regarding the legal errors here. Therefore.
You'll have to file several petitions, maybe limitation.
for service of notice, some of the
Once a
respondents
petition
actually.
is accepted, Start the court's permission has to be taken. And the case, I had some time to look at the case itself. There is nothing much in the case because they have purchased the land through sale deed. And they are saying their father used to owe them 50 years ago. But then the sale deeds has been executed in court. The case there itself, there is nothing. So this may be an excuse just to delay the matter.
It's are more than 30 years old.
So
As per law, it's.
here, I actually in the main appeal, I cannot file,
No, no,
pass any
appeal-
order. Main
May-
appeal, you will have to file petition for, one will be for limitation, I am sure.
Abatement set aside,
Then to
condonation of
substitute-
delay, substitution, all these three are to be
We'll have
there,
to
but already
petition.
time elapsed.
So we'll list it then.
So it's their onus, they will appellate, but
4 weeks
there
time
is
may be
nothing in the
taken,
case.
Nothing in the case because and this may be an excuse because they know the case they cannot win. So they are just allowing you to lie around. That is what I saw.
But there is no, I think there is no stay order.
Stay there is nothing.
No.
So
No
let
stay.
them do whatever they like.
Yes, ma'am, that. But regarding the substitution, already it's
Yes,
abated
if
for
the
against.
Function doesn't arise because it is a case is finished. It has ended.
Ended in your favor.
Yes, in the favor of.
In
the
favor
In
of
your favor,
respondents,
that-
And for the state of Assam.
numbers of respondents, my lord.
I am showing my concern because I am the state, my lord. This thing should not be allowed.
In fact, the addresses are also
Kind of anarchy is going.
Correct. But her senior's not, I think her senior's,
Yes.
is busy somewhere else.
Yes, yes, your
No, what may they may ask their clients whether they are serious in person. Instruction they can take.
Learned Counsel Miss Edmund
R-
also.
R. Kalita.
R. Kalita is present on behalf of Learned Counsel Mr. S.K. Sarkar.
SK sir.
Who's of Learned Counsel Mr.
KM. Hello, I am for 34. That's my number.
K.M. Halleri is present for respondent number 34 and learned government advocate.
Yes, for 2, 3 and 4.
Learned government advocate, Mr. K.K. Bhattacharya is present for respondent number 2, 3 and 4. Full stop. It is submitted that which respondent has passed away?
Yes, Your Lordship.
Which respondent has passed away 2 years back?
15, 19, respondent number 15, 19, 29, 31, 32, and 47. Your Lordship.
It is submitted the respondent number 15, 19, 21.
15, 19, 29, 31, 32, and 47.
Have passed away.
And the substitution petition which the court has already allowed for the appellate number 1, they have 3 children, I think. So that has been served on us.
It is
The petition has not been served on the government.
The learned counsel for the respondents have submitted that the appellants have the aforementioned appellants have passed away 2 years back, and this case have been automatically abated.
No, I think appellant number 1 is substituted.
No, and this case may have been abated against
Those respondents.
automatically abated against those respondents. On the contrary, it is further submitted that the substitution petition for substitution of the legal heirs of respondent number 1 has been allowed. It is also submitted by the learned counsel for the appellants that the appeal has no merits and this case is pending, and there will be no fruitful result on prolonged pendency of this case. I list this matter again as the learned senior counsel is not present, as the learned leading counsel, as a learned senior counsel.
No.
As the learned counsel, Mr. S.K. Sokha is not present today. List this matter.
Maybe after, because they.
After vacation. After vacation, you can pursue whatever you want.
By registering.
Execution or anything.
Substitution, if they will file, it will come.
Substitution. List this matter after vacation. Then we will go through everything, whatever they want to do.
Much obliged.
Much obliged.
Item number 30.
That clear, Lordship. Can it be after vacation, Lordship?
Can be. I
is there. 11 witnesses there, so it will take time.
list this matter after vacation.
Can it be on 18?
Yes, can be. List this matter on 18 July.
Obliged, Lordship.
Item 31.
My lord, as for the office note, my lord, 10/6/2024, my lord, service upon the respondent number 2, my lord, completed, my lord.
Completed.
Lordship. So, my lord, let matter may fix for admission, my lord.
Hmm.
And there is an interim order, my lord, till then, my interim may continue, my lord. 10/6, my lord.
Learned counsel, Mr.
Ellen Dingham, my lord.
Ellen Dingy is present for the petitioner. Office note dated 10/6/25
10/6/25.
reflect that notice has been served to respondent number 2. It will ever check with the process check with the notice has been served to respondent number 2. Yeah, that's any.
Flag mark, my lord.
LCR call kora hol niki? Do we need the LCR?
LCR also not called for, my lord. My lord,
Call for the scan copies of the trial court records. List this matter for admission.
lordship. My lord, interim order, my lord, may continue.
Interim order shall remain in force till the next date of listing. List this matter, call for the scan copies. List this matter after vacation.
Obliged.
Item 34. 32 होगा मुझे? Oh, अच्छा.
May I plead the Lordship? This is an IA, my lord, for condonation of delay of 92 days for referring the connected criminal evidence petition, my lord.
Lordship, I have filed an objection, Lordship, in this respect.
92 days.
Lordship, the thing here is my submission is this, Lordship. An interim maintenance was granted 4,000 per month on 24 Lordship, it was granted on 24/4/2024. Lordship, from that day till this day, Lordship, they have made only 2 times. They have not attended the counseling sessions, and this is a mere ploy to delay the entire proceedings, Lordship. They are yet to pay area maintenance of around 48,000, Lordship.
Lordship, I have submission, ma'am. Quarter 7, 4,000 has, interim order has passed. In the meantime, in the DV case, pending for the consideration of interim order. Out of same documents, same facts, same assets and liabilities, the Honorable Family Court passed the interim order of 4,000 rupees, and after 2 months, the learned court below, my lord, SDM, no? Learned court, JMFC, my lord, rejected their interim pair, my lord. That's why they have come, they have two months late to come before this honorable court, because they had to wait for the outcome of the DB case. This is my, for that reason, the 90 days are.
Lordship, in their petition, Lordship.
And condonation of delay may not be a final order for the restraint the any of the order, my lord. This is the only for condonation of delay.
Lordship, in their paragraph number 6, in their petition, Lordship. I am just reading, Lordship, from their petition, Lordship.
And in fact, 3 days.
Let me submit. The petitioner begs to state that upon receiving the certified copy of the order dated 24/4/2024, the petitioner could not immediately contact the present set of counsel as per petitioner, as the petitioner works outside Guwahati in Aminga and comes home late at night. It is pertinent to mention here that in the meantime, the father of the petitioner, who is a senior citizen, was suffering from various ailments, suddenly fell ill during the time due to which the only son had to be engaged in medical related works.
Then come to the para number 7, my lord. Then come to the para number 7.
Lordship, I am just saying. Lordship, then paragraph.
Which you are reading para number?
Paragraph number 6, Lordship.
Okay.
Then, Lordship, I am reading from paragraph number 9.
Para number 6 of the petition.
Yes, Lordship. But then I am reading paragraph number 9, Lordship. The petitioner begs to state that during the first week of October 2024, the father of the petitioner became stable, and thereafter the petitioner approached the present set of counsel. Now, Lordship.
Which one are you reading? The IA?
Yes, Lordship, the IA. Page 4 and page 5, Lordship. Page 4 is paragraph number 6, and page 5 is paragraph number 9.
Okay.
Should I read paragraph 6, Lordship?
Yeah.
Yes. In paragraph number 6, it states that the petitioner begs to state that upon receiving of the certified copy of the order dated 24/4/2024, the petitioner could not immediately contact the present set of counsels, as the petitioner works outside Guwahati in Amingaon and comes home late at night. It is pertinent to mention here that in the meantime, the father of the petitioner, who is a senior citizen, was suffering from various ailments, suddenly fell ill during that time, due to which, being the only son, he had to be engaged in medical related works. This is paragraph number 6, Lordship. Now come to paragraph number 9, Lord.
Then why did they not come to paragraph number 7?
Lordship, just I am trying to point out something, Lordship. The petitioner, paragraph number 9, I am reading, Lordship. The petitioner begs to state that during the first week of October 2024, the father of petitioner became stable, and thereafter the petitioner approached the present set of counsel. Now, in between this, Lordship, they filed a divorce petition in 21/8/2024. If the appellant revisionist, he did not have time to consult the present set of counsel, how can he file a divorce petition in 21/8? Lordship, for that purpose, Lordship, I have annexed the notice, Lordship. The notice is on page 30 of my objection, Lordship. Page 29, Lordship. FC Civil Case number 1074 of 2024. It's a notice, Lordship. Notice for the divorce case, Lordship.
Page number of your objection?
Page number 29, Lord. Of my objection, Lord.
You come on next date.
Lord.
List this matter after vacation.
A date may be fixed, my lord.
Date at a delay. Both the parties are represented. List this matter on 22nd July.
23rd?
22nd July.
22nd already High Court of both the matter listed. 23rd July, Lord.
Obliged.
Item number 36.
Wait, please, Your Lordship. This is petition. I have come against the FIR vis-a-vis the charge.
Can I get a break for 5 minutes?
My lordship.
Can I get a break
Yes,
for
yes,
5
my lord,
minutes?
please.
Lordship.
Only for 5 minutes.
Yes,
I'll
lordship.
continue till the evening.
Yes.
Don't worry.
No. Proceed and the proceedings of a PR case, my lord.
Mm.
My lord, the petitioner, he was, my lord, serving as an employee of Hero
This is in
Corporation.
the order stage.
Yes, my lordship. The
Today I have appeared for the informant.
Uh.
Because out of the court settlement has been taken place. The lordship may quasi it, I don't have any objection, lordship.
Okay.
Because it was adjusted, loan was adjusted after taking the motorcycle.
Can pass an order.
Lordship.
Third learned counsel, Mr. M.K. Das.
my lord.
For the petitioner. Former learned
D. Talukdar.
counsel, Mr. G. Talukdar.
D. Talukdar for respond number 2.
D. Talukdar for the respondent number 2. And learned additional PP, Mr. B. Soma for the respondent state. The petitioner has filed his application for the petitioner Birbal Sahu.
My
Bisal
lord,
Sahu.
Lordship.
Bisal Sahu.
Vishal.
Not Bisal Pupar, no?
It's not man.
The petitioner has filed, Bisal Sahu has filed his application under section 28 of the BNSS 2023. With prayer for setting aside and quashing the FIR being June IPS case number 60 of 2024. And charge sheet being CS number 38 of 2024. Dated 30/6/2024. And the entire proceedings of PRC case number 68 of 2024 pending in the court of the learned SDGM within bracket M at Junai, Hamaji. The allegation against the petitioner is that where is the FIR?
FIR, my lordship, will find at page 20.
Next country.
Lord, translation is 20, Assamese vernacular 22.
Yes, okay. The petitioner under the direction of the petitioner directed the petitioner number 1. The petitioner directed the
Accused number. My lord, one accused has come before this honorable court.
accused number 1.
Two, my lord, Bisal Sahu.
Yeah, I know.
Other
The
two,
petitioner directed the accused number 1, Biju Payar, advice लिख दिया ना नहीं तो advice ना लगे. The the allegation against the petitioner is that the accused number 1, Sri Biju Payar, on the बाकी direction director पे कटेगा, on the advice of the petitioner, took away the motorcycle from the informant's wife during the when the informant was during the absence of the informant. Full stop.
in the month of September 22.
The motorcycle was taken away from the informant's wife in the month of September 2022, and this motorcycle was purchased from the financer on 20/02/2022. The informant then received a phone call on 19/6/2024 that the motorcycle was taken away as he had to pay the installment of the aforementioned motorcycle. All right.
My lord.
Learned counsel Mr. D. Talukdar has submitted that the Respondent number 2,
Respondent number 2.
IE. Sri Bipul Patil
Vipul Patil.
has received the what?
Now, already it has been adjusted and no money has been demanded by them now. Because they have adjusted the installment with the motorcycle.
Respondent
now the
to IE Bipul
loan is
has
closed.
admitted that
The loan is also.
the loan is already closed. There is no dispute relating to any money to be paid by the
informant to the petitioner.
informant to the petitioner. Post of the matter has been amicably settled between both the parties. There was a misunderstanding between both the parties which resulted in this dispute. Post of no offense under section
420.
420/34 IPC has been made out as the money has already been adjusted. The informant has no objection if the FIR is
FIR along with charge sheet.
FIR along with the charge sheet is set aside and quashed. I have considered the submissions at the bar with circumspection. This matter has been amicably settled between both the parties. This is a matter of relating to a dispute arising out of money transaction, which is very personal in nature. As both the parties have settled the dispute amicably and have buried the hatchet, BURIED, buried the hatchet, HATCHET, possibility of conviction appears to be remote and bleak, full stop. Indeed, further proceeding will be an abuse of the process of the court. Thereby, the entire proceeding of PR case number so-so arising out of Junai PS number so-so and Sarsit number so-so are hereby all set aside and quashed.
So for this petition is now because there are
Oh,
three
yes,
accused.
yes.
Three accused.
Qua the petitioner, so far as this petitioner is concerned, is set aside and quashed. In terms of the above observation, this application stands disposed of. So far as this petition is concerned. Yes.
Yeah, please. The I for condemnation of delay of 20 days in a Canadian appeal. And the last two occasion information was sought from the learned PP whether the same has been received for the respondent, private respondent information.
My lord, here. Office note also 1/5/2025, my lord. On that the PP office has received the copy, my lord. Thereafter, up to date, my lord, office note is also not here, my lord. And from our office also not receive any information, my lord. I will take further time, my lord. I will have to take time.
Learned PP to obtain instructions if notice has been served to private respondent number 2. List the matter on A2
Lordship, he is
before
on.
vacation DDR. 25th.
He is in jail, your lordship.
I know.
Yes.
25th June.
My lord.
Item 39. Item number 39.
My reason, lordship. Also, this is I for condemnation of delay, total 42 days, my lord.
No
42 days, my lord.
Posco? No Posco.
No, my lord. This is
Learned counsel Mr. A.K. Azad
AK Azhar.
is present for the applicant.
Arising out of my lord.
Stroke applicant. Prasant Garg, who has filed his application under Section 5 of the Limitation Act 1963 with prayer for continuation of delay of 42 days in filing the collected civil criminal revision petition. Full stop. Oh, state?
My lord.
State? What kind of application is this?
No, my lord. Criminal revision against the, my lord.
State is not a party.
Judgment, impugned judgment. No, state is a formal party here. 39.
What judgment?
Judgment arising out from FC criminal case number 389/22 by the principal just family court, my lord. This is maintenance matter.
125.
My lord.
125.
125. My lord.
Oh, no, you'll have to issue notice. Issue notice to the respondent, list the matter of, issue notice to the respondent returnable on July date of the DDA. 23rd July, list the matter, list accordingly.
My lord. Master bless. Worship, on a humble submission, can it 37, can it be on the next week, your worship? Because if the main appeal is also yet to be numbered, your worship.
On 20.
Public.
Item number, which were? 20.
My lord, this NI proceeding case already amicably settled between the parties. So 13 lakhs 28,000 was the settlement amount. Already we have paid 6 lakhs 70,000 lordship till yesterday. So we'll keep on paying lordship. It may be fixed after a month by the time also.
As agreed by both the parties, list this matter on data media. It is submitted by learned counsel Mr. D. Das that the petitioner has already paid rupees 6,20,000.
70,000.
6,70,000 out of
13 lakhs
13,20,000. Good stop. Learned counsel Mr.
S. Vaishya.
Miss S. Boshe is present for the respondent number 2 and has submitted that they have received rupees 6,70,000.
Yes.
Learned, any other party?
State is a formal party.
Learned additional PP Mr. B. Soma is present. List this matter on 23rd July.
Lordship, I have another prayer. Except myself, Lordship Ditul Das, A. Talukdar and MS Tinglung, the other councils are not appearing. Their names may be deleted.
The names of other council, the registry to reflect the name of only learned counsel Mr. Ditul Das,
A. Talukdar and MS Tinglung.
A. Talukdar and
MS Tinglung.
MS
Tinglung. Last.
And MS Tinglung
Not
as learned counsel representing the petitioner. Those are the names of the other council may be deleted.
Lots.